Any mention?
Wait, please, Your Lordship. Lordship, I beg to make a mention of item number 7. Item number 7, Your Lordship.
Yes, who's for the other
Your
side?
Lordship, I've already informed.
You sought the consent.
Yes, Your Lordship.
You are for?
Respondent number 8.
You are mentioning which item?
Item 7, sir.
7. I mean, this is your lordship. Lordship item number, see, 6, 6, 7, 8. Your lordship, these are. 6, 7, 8. Let me see. Just a minute, lordship. Can we have 6, 7, 8? Your lordship, these are. If one is adjourned, then other also will have to be adjourned, your lordship.
You are appearing in only 7 or
Yes, Your Lordship.
only in 7?
Lordship, I am item 8. Lordship.
8.
9, 10.
And who's in 6?
For 6 and 7, I'm appearing in 8 and 9 and 6, and 9 and 10 and 7.
What is the issue here?
Lordship, the issue here regarding the appointment of school teacher, lordship, where the other party they have challenged the appointment of the private respondent, your lordship, because it entering, your lordship, relates to the managing committee also, your lordship.
No stay.
There is no stay, your lordship.
Okay. After vacation. So we'll.
Then let it come along now, your lordship.
6, 7, 8, same.
6, 7, 8, your lordship. 7, 9, 10. 9 what?
So, any objection?
Lordship, it appears also item 9 also, your lordship, has been tagged with writ petition number 342, that is item 6. Lordship, can we have a look at item 9 in the cost list and down below, your lordship, along with 342 of 2022, your lordship, that is item number 6, your lordship. Lordship, can you
So
turn to
who are the
item,
parties in
lordship,
9?
Item 9, I am appearing for the state respondents, Lordship.
Your Lordship,
In
I am
item
the
9, Lordship,
petitioner.
it's regarding the payment of salary to the petitioner. But the appointment of the petitioner is under challenge in item 9, on item 7, Lordship.
Your Lordship,
Item
in
6,
item
7.
number 9, I am the petitioner.
You are a petitioner.
Go for that side.
Okay. So, 6, 7, 8 and 9
And 9.
Lordship, yes. Come together on this.
on pre-made by the parties. This is matter after 3 weeks.
Apply, lordship.
Wait, please, Lordship.
May I please, Your Lordship?
Yes. Yes.
I beg to mention item number 10 and 11.
Yes. You are appearing for?
For petitioner,
Have you
on
sought?
behalf of Viri.
Have you sought? Yes. You are for the respondent.
No objection, Your Lordship.
On pre-made by the petitioner. This is matter after 3 weeks. 10 and 11.
Wait, please, Lordship. Lordship, I beg to make a mention of item 5.
Item.
5, Your Lordship. Lordship, this is legal aid matter, Your Lordship. I'm appearing on behalf of Miss Ardata, Your Lordship. She is the legal aid counsel, Your Lordship, in this matter.
But she was here.
Lordship. Lordship,
Why she is not appearing?
Lordship, she's on legs before court one, Your Lordship.
So,
Lordship, state is only the state was the main is the Union of India, Lordship. Only the state is called whether we do have the list of OBC or not, Your Lordship. That we have. That is the only issue, Your Lordship. We do not have the list, Your Lordship.
On premier by petitioner, this is matter up to 3 weeks.
Apply, Your Lordship.
May it please your lordship, I beg to mention item 17, your lordship. 17, 17.
17, you are mentioning 17.
16, even 16.
Lordship, if 17 is
Connected.
taken out from the list, Your Lordship, then item number 16 to 19 will have to, Lordship. These are all connected, Your Lordship.
And then item 16, 18 and 19, Your Lordship. Under petition.
So same prayer.
See,
Prayer
Will
made
come
by,
after 3 weeks, then, Your Lordship.
prayer made by the petitioner, this is matter up to 3 weeks.
That should like
So that's 16 to 19.
16 to 19, Your Lordship. These are analogous, same issue, Your Lordship.
What is the issue here?
Lordship, this is regarding the diploma, 18 months diploma. There has been
versus 2 years diploma course
2 years and 18 months diploma.
for the
They
above,
have,
your lordship.
they have challenged because they say the private respondent are 18 diploma. That have been clarified by the Honorable Supreme in a subsequent judgment, Your Lordship. That will please before Your Lordship at the time of hearing, Your Lordship.
Okay.
Apply, Your Lordship.
Your Lordship, I beg to mention item number 15. Your Lordship, here the petitioner has just filed the rejoinder yesterday. So, Your Lordship, I'm praying for some time so we can go through the same.
Lordship, no objection. They have filed a belated affidavit, we filed a rejoinder. After puja vacations.
On prayer made by Ms. Naratji, matters adjourned. This is after 3 weeks.
Obliged, Your Lordship.
Please, Lordship, I beg to mention item number 13, Lordship.
Practically, the whole list is gone.
I'm praying for that this matter come after puja vacation.
Why?
The conducting counsel is not available today, Lordship. He went out of station. Mr.
Who
Sheikh.
is the conducting counsel?
S.A. Sheikh, Lordship.
Sheikh.
Yes, Lordship.
Sheikh, my lord, there was a this matter was heard at length before the court bench, Lordship, and the issue which was to be considered was whether this matter was hit by delays and arches, Lordship.
Okay. That is a matter of merits.
Lordship.
On prayer made by the petitioner, this is matter of the 3 weeks.
Much obliged, Lordship.
Daily list item number 1.
My lord, this matter is still pending for the Honorable Supreme Court, Lordship. The matters were still pending for the before the Honorable Apex Court, Lordship.
Lordship.
Pursuant to this court's order dated 5/8/2025, wherein the submission of the parties have been noted to say that matters pending before the Supreme Court. Stop. Till today, the situation has not changed. As such, the parties have sought for suitable accommodation in this matter. As prayed for, this is matter after 4 weeks.
Obliged, Your Lordship.
Item number 2.
Same order, Your Lordship. It's connected.
Same order.
Item number 3.
Yes, who's appearing in 3? None appears for the petitioner. Office note would show that the notice issued upon the respondents have not yet been effected, inasmuch as the AD card has not yet been received by the registry. Accordingly, let the service report be awaited. This is matter after 3 weeks.
Item number 4.
Yes, Mr.
Lordship, as per last order, the legal in council is appearing for the complainant. Lordship.
Okay. So you are appearing. We'll hear the matter.
My lord, if the matter can be taken up tomorrow, Lordship, I didn't get to read the brief today, Lordship.
This is your first appearance? Miss Lanet, legal aid, your legal aid counsel? Legal aid counsel has entered appearance on behalf of the respondent number 3. Mr. H. Karolang, Lanet, additional PP, has submitted that sought for accommodation on the ground that he is not prepared to be heard in this matter today. As agreed to by the parties, this is matter for hearing tomorrow.
Give your
Item number 12.
May it please your lordship. My lord, in this matter, my lord, the appellant has been convicted in a POCSO Act, my lord, for 7 years imprisonment under Section 6 of the POCSO Act, my lord. But during the pendency of this appeal, my lord, we have filed an application, Miss Case number 56, my lord, of 2024.
is a matter where we are petitioner. She's a in-service teacher of a school, Lordship, since the year 2021. Pursuant to an advertisement and everything, she has been selected. What is very important here is, Lordship, that the school is a single teacher school. She is the only teacher in the school, serving till date. But your Lordship, the proposal to regularize her or to give her a sanctioned post under the government, proposal was made over by the managing committee, and that has not been approved, Lordship. But the fact remains that till date she has been serving in the school. She is not getting the salary also because of the non-approval of the appointment. And Lordship, now the state has filed its affidavit.
Yes.
Essentially, they have taken 3 grounds, as to why they have not approved, Lordship. The first ground that they say was that the interview was not conducted properly.
Yes.
The second ground that they say, Lordship, was that the petitioner was overage. And the third ground they say that there was no MTET. Lordship, my humble submission to that was that the interview which was conducted was duly conducted, publication was made in the newspaper, and the school managing committee has conducted the interview and selected the petitioner and recommended her appointment to be approved by the state. And it is not the case of the managing committee, Lordship, that the interview was not done in a correct manner. What the state is saying is, Lordship, that it was during COVID time. So that time there was a protocol of under 144 CRPC and not to have any gatherings and all. So interview could not have been conducted. What the managing committee has stated in affidavit is that, Lordship, because although it was COVID time, considering that it was a single teacher school, if no teacher would have been appointed, the school would have been left, the students would have been left hanging, and in that circumstance they went ahead with the interview and they selected the petitioner, Lordship. With regard to the issue of overage, Lordship, I don't know why they say I am overage, because here the petitioner is an scheduled caste OBC candidate, sorry. An OBC candidate, they have a age relaxation, and the petitioner falls very much within the age limit of the OBC category, Lordship. And with regard to MTET, Lordship, I have 2 submissions.
Lordship, in this matter, Lordship, since my friend has spoken about the MC also, the MC has already been represented, but there's no counsel today because the MC is the main person to explain to this honourable court the ground, the ground effect of what has happened, what has transpired to this present petition, Lordship. It's at respondent number 5.
MC respondent number 5.
Lordship, yes, in fact they had.
We are 1 to 4, Lordship.
Oh yes.
They had.
They've already entered appearance also.
And filed an affidavit
Yes.
also.
Oh. Then they should be present.
They should be present today, Lordship, if the deliberations are to be completed.
Have they made any appearance?
They've entered appearance, Lordship.
Who's the counsel?
Certain affidavit filed by Miss K. Litep. I think, Lordship, maybe because of if I recollect, Lordship, she is having suffered a stroke recently, maybe because of that reason.
The counsel?
The counsel. I'm just seeing the name who has identified the affidavit, Lordship, filed by the managing committee. Perhaps she's the counsel. In the cause list also her name has been mentioned.
Yes, Miss K. Litep.
Yes. K. Litep, Lordship, for my information, she's recently suffered a stroke, so she's still paralyzed, I am told, Lordship. But I did not know.
It's unfortunate, my lord. I mean, I was not aware of that
I
situation.
just saw the name.
No,
Yes.
in fact, some time ago, I heard one of the members of the bar.
In fact, Mr.
Just a AG
Mr.
moment,
Momin
Lordship.
also, Mr.
He suffered a stroke.
Adaya
Yes.
Momin also in a similar.
The person who always sings when Lordship comes to
I
the
heard
bar.
about him. So how is he now?
He's recovered.
recovering,
He's
I am
recovering.
told,
He's
Lordship.
recovering, Lordship.
In Gauti, I think.
Yes,
if I'm not mistaken.
Gauti.
Similar with Madam Kerwani Litep, I think. She is also. So, Lordship, may.
So my advice to the counsel is not to take too much tension.
Lordship, yes, absolutely.
Lordship, it's
You
easy
see,
to say, but very difficult to do.
I still remember my senior when I started practice. He will tell me very, very, emphatically that you should not be emotionally involved in any case.
Right.
Because if that's the case, then you get all these stress and tension.
In fact, nowadays lifestyle problems are also there.
Very unfortunate. Very unfortunate.
Lordship, in that event, I may pray
What
that
do we
the
do,
matter will be taken up after puja. I'll just try to contact her and
Perhaps.
Lordship.
Yes. Otherwise, notice has to be issued.
Lordship, I'll just Lordship may just adjourn it for the day and have it after puja. In the meantime, I'll try to contact my Lordship. And
On pre-made by Ms. SDEP and counsel for the petitioner. This is matter after 3 weeks.
much obliged, Lordship.
Item number 20.
Please, Your Lordship. Lordship, this is an appeal against award passed by MACT Shillong. Fairly straightforward appeal, my lord.
Appeal number 3.
My lord.
Yes, please.
My lord, if I can take just a minute just to set out the background. There was an accident, my lord, between a motorcycle and a scooty, my lord. Motorcycle, my lord, was insured with us, and respondent number 2, against whom the matter has already gone ex parte, respondent number 2 was our insured person, my lord. He was riding the motorcycle. There was apparently a collision between motorcycle and scooty. The rider of the scooty, that is the husband of the claimant, he suffered certain injuries. MACT claim was filed, my lord. MACT claim was processed. Finally, my lord, award was passed by MACT Shillong sometime last year, 25th October last year. And under the award, my lord, an amount of 12,93,787 has been awarded, along with interest at 8%, my lord. Now, the reason why we are challenging this award, my lord, there are about 3 or 4 reasons, my lord. 3 or 4 broad reasons. The first pertains to the issue of negligence, my lord. It's a petition under 166 Motor Vehicles Act, so negligence has to be proved, my lord. Now, in this case, the first question that lordship will have to apply lordship's mind on is whether, on the basis of the materials, the MACT could have come to a conclusion that yes, indeed, respondent number 2 was negligent and had caused the accident through his negligence. In this respect, I draw lordship's attention to para 23 of the impugned judgment, my lord. Impugned judgment starts at page 43 of the memo of appeal.
Appeal of paperwork.
It's in both places, my lord. Memo of appeal, if lordship sees, 43. It starts from 43.
Paperwork has been filed, Mr.
It has been filed, my lord.
Would it be convenient to refer to the paperwork?
Normally, yes, my lord, but the slight difficulty is I've already made my markings in my personal notes in the memo of appeal. I seek lordship's indulgence, my lord.
Page 43.
43 it starts from, my lord.
Yes. Yes.
And as far as the issue of negligence is concerned, my lord, I draw lordship's attention to para 23 of the judgment, page 48 of the memo of appeal. Page 23, my lord. Para 23.
Yes.
Now, para 23, my lord, MACT has discussed the evidence of CW3, who was the IO of the case, my lord. Now, 23, I'll read, my lord.
Yes.
CW3 stated that during his investigation, the accused and the victim, after they had met with the accident, does not know how the accident had occurred. And the pillion rider also stated that the rider of the motorbike and the scooty became unconscious after the accident. So he lifted both of them on the roadside. So, my lord, I'll just take a pause, my lord. On my insured motorcycle, respondent number 2 was the rider, and there was a pillion rider, my lord. So, both respondent number 2 and the victim both became unconscious. Pillion rider took them to the side of the road, my lord. Para 24, my lord. CW3 stated that as per the pillion rider, on reaching at MES point near Military Hospital, Shillong, one unknown Omni private car moving on the same direction hit the bike and then hit the scooty, which was coming from the opposite direction, and both the bike and the scooty fell down. The unknown Omni private car fled towards Old Chera petrol pump, and the pillion rider, with the help of the passerby, pushed the motorbike and scooty and parked by the side of the road. The pillion rider, after the accident, called for help, and after some time, one eco private car helped him in transporting the injured persons to Civil Hospital, Shillong. Next para. CW3 admitted that no other person had seen the accident except the pillion rider of the motorbike driven by Shri so-and-so, but CW3, on completion of the investigation, filed charge sheet against the accused Shri so-and-so, respondent number 2, that is. Now I'll just pause, my lord. CW3, the IO states that nobody else saw the accident except the pillion rider. He has recorded pillion rider's statement, which is to the effect that one Omni van came, first hit our insured motorcycle, then hit the victim's scooty and fled away towards Chera petrol pump. That was the clear, unambiguous statement. Surprisingly, CW3, after recording that statement, files a charge sheet against my insured person, respondent number 2, my lord. Now, there was no basis for the charge sheet, firstly, my lord. Secondly, the effect of the charge sheet can be seen, the effect it has had on the MACT can be seen at para 31, my lord. I'll read, my lord. Yes. The fact that CW3 filed charge sheet against the OP number 2 shows that there is a prima facie case that OP number 2 had driven the motorbike in a rash and negligent manner on the day of the accident, and the accident took place due to rash and negligence of the driver of the motorbike, registration number so-and-so. So negligence has been found against respondent number 2 by the MACT merely because charge sheet has been filed by IO against respondent number 2, my lord. Now, firstly, as evident from the materials, from the evidence, there was no basis for that charge sheet. IO should have made endeavors to locate that Omni van. Nothing of that sort was done. Statement was recorded that Omni van has caused the accident. Charge sheet is filed against some other person, that is respondent number 2, my lord. So, number 1, there was no basis for the charge sheet. Number 2, even assuming for a moment that there was some basis for the charge sheet, the filing of the charge sheet against a certain person, in this case respondent number 2, could not have led to a presumption of negligence against respondent number 2. The law is very clear that the criminal proceeding that arises out of an accident, the evidence in that proceeding, the findings of that proceeding cannot have a bearing on MACT proceedings, my lord. In this connection, if I'm allowed, page 9 of the memo of appeal may kindly be looked at. Page 9, I have taken the liberty of extracting a 1993 judgment. I will give copies when I submit my synopsis, my lord. Page 9. 9. The judgment is there, my lord. Mahila Dhanvati versus Fulwant Mahindra Singh. And the extracted portion is from para 10, my lord, of that judgment. I'll quickly read, my lord. Coming to the other contention that the deceased was traveling as a passenger and therefore the insurance company was not liable to pay any compensation, it has also no merit. True, the FIR exhibits so-and-so and the statement of the investigating officer gives a version which support the case of the insurance company, but even assuming that the FIR is a public document, but it is the rule of law that it is not a substantive piece of evidence. It can be used only for the purposes of corroboration or contradiction of the maker only. The maker having not been examined by either side, the statement of A.S. Yadav carries no weight as he only investigated the occurrence. He is not an eyewitness to the occurrence. His testimony is of hearsay evidence. Therefore, the conclusions which he draws after the investigation cannot be taken into consideration unless supported by proper material. It is well settled, I stress on this, my lord, it is well settled proposition of law that evidence recorded in criminal court and the findings arrived at thereon should not be used in claim cases. Such evidence for the purposes of claim cases is inadmissible. So, my lord, the logic behind this, and this is a regularly repeated position of law, my lord, that what happens in a criminal court after an accident has taken place, what happens in a criminal court cannot have any bearing on a MACT claim. The logic behind this, I would humbly submit, my lord, is very simple. The logic is that the standard of proof that is required in a criminal court is far different than that which is required in a MACT tribunal, my lord. In a criminal court, Lordship is very well aware, the crime has to be proved beyond reasonable doubt. In an MACT, my lord, preponderance of probability is more than enough, my lord. So that being the case, what happens in a criminal court cannot have any implications or bearing on a MACT claim, my lord. In this case, in our case, the fact that charge sheet has been filed against respondent number 2 has been taken to be evidence that negligence was of respondent number 2, my lord. My lord, in my humble submission, that is an unsustainable finding. Negligence requires direct evidence of negligence. The fact that in a criminal case, there is a charge sheet that has been filed, firstly, cannot have any bearing. And secondly, going behind that charge sheet, Lordship will see there was no basis for that charge. We are not even aware what was the outcome of that criminal case. But the very fact that there was a third vehicle involved, which the IO never investigated, shows that the fault or the negligence could not have been of respondent number 2, my lord. So that is the first ground on which we are assailing this award, the finding of negligence. Our submission before this Honorable Appellate Court is very simple, my lord. Negligence could not be established by the claimant. Negligence had to be established by the claimant. Negligence could not be established by the claimant. The learned MACT, with respect, was wrong in the approach it had adopted by referring to a charge sheet and saying that this shows negligence was there. That cannot be a correct approach, my lord. First point on the question of negligence, my lord. The second ground that we have adopted, my lord, is on policy violation. Now, why I say policy violation, my lord, is because it is undisputed, I think, at the bar, that respondent number 2, the rider of my insured motorcycle, he was holding a learner's license, my lord. Now, once a person holds a learner's license, the rule is very clear, my lord. He is required to be accompanied by another person holding a proper full license, my lord. Now, just for Lordship's convenience, if I can draw Lordship's attention to the motor vehicle rules of 1989. Rule 3, my lord. Rule 3.
Rule 3.
Rule 3, my lord. That is under Chapter 2, my lord. Chapter 2 dealing with licensing of drivers of motor vehicles. I'll read Rule 3, my lord. The provisions of subsection 1 of subsection 3 shall not apply to a person while receiving instructions or gaining experience in driving with the object of presenting himself for a test of competence to drive, so long as, clause B, my lord, such person is accompanied by an instructor holding an effective driving license to drive the vehicle, and such instructor is sitting in such a position to control or stop the vehicle. So, requirement, my lord, a very well-known requirement and codified in the rules itself, that if you're holding a learner's license, then you need to be accompanied by a person holding a full effective license, my lord. Now, in this case, there was a pillion rider, like I had mentioned. But whether the pillion rider himself held a full effective license has not come on record, my lord. has not come in record. What the respondent number 2 has brought on record is his own learner's license. But since he held a learner's license, it was incumbent on him to produce evidence to show that the pillion rider, if no one else, was holding a valid, effective driving license. That was not done, my lord. Now, in that situation, what has the MACT observed, my lord, can be found at para 38 of the judgment, my lord. Para 38, that is at page 51, my lord. Page 51, para 38.
Yes.
This is on the issue of policy violation and violation of the rules, my lord. This tribunal found, para 38, my lord, this tribunal found that Exhibit A shows that OP number 2 was holding a learner license at the time of the accident and having a pillion rider, but it has not been brought on record that the pillion rider accompanying the OP number 2 was having a valid driving license or not. OP number 2 did not bring evidence from his end. This is crucial, my lord, in view of what the Supreme Court says, and which I'll show. OP number 2 did not bring evidence from his end to show that the pillion rider was having a valid driving license. Therefore, it is found that there is breach of condition of insurance policy by OP number 2, since it is not established that he was accompanied by a person having a valid driving license at the time of accident, but such ground cannot waive the liability of OP number 2 with regard to the rash and negligent driving of OP number 2 who has caused the accident. I'll just pause, my lord. So very clear finding, very correct finding by the MACT that there has been a breach of policy condition, because by holding a learner's license and not being accompanied or not bringing any evidence to show that you were accompanied by a person with a full license, it amounts to not having a license. It amounts to violation of the rules, the requirements of the rules. It amounts to violation of the policy conditions. So the first observation in para 38 that there has been a breach of policy conditions, very correct observation. I have no fight with that observation. However, the second part is where, respectfully, my lord, I point this out, the second part is where the MACT appears to have gone a little wrong. Second part to the effect that such ground, the fact that there's been a policy violation, cannot waive the liability of OP number 2 with regard to the rash and negligent driving of OP number 2 who has caused the accident. Now, the consequence of this is that the insurance company will be held liable. The insurance company is to be held liable because of the fact that even though there has been a policy violation, insurance company, MACT has held insurance company as liable, giving us the right to pay and recover. That right has been given. But before this honorable court, our point is a little different, my lord. Our point is that holding a driving license, a learner's license, and not being accompanied by a person with a full license amounts to no license. A case of no license is different from a case of defective license, fake license, etc. If it is a case of no license, the consequence, as per the Supreme Court itself, is to release the insurance company from any liability. So, as I said, we have been kindly given the right to pay and recover. But pay and recovery, my lord, is a Pyrrhic victory. In about the last 20 years, there has been only one case to my knowledge where we've managed to recover anything, my lord. So, to give us the right to pay and recover amounts to nothing, especially in view of the law laid down by the Supreme Court. That law, my lord, can be found at page 10 of the memo of appeal, my lord. Page 10, towards the bottom, my lord, Pappu versus Vinod Kumar Lamba, 2018.
Yes.
Now, I'll read this judgment, my lord, the extractor portion. This court in National Insurance Company versus Swaran Singh so-and-so has noticed the defenses available to the insurance company under section 149(2), etc. The insurance company is entitled to take a defense that the offending vehicle was driven by an unauthorized person, or the person driving the vehicle did not have a valid driving license. the onus would shift on the insurance company only after the owner of the offending vehicle pleads and proves the basic facts within his knowledge that the driver of the offending vehicle was authorized by him to drive the vehicle and was having a valid driving license at the relevant time. I'll just pause, my lord. As per Supreme Court, my lord, that we have defenses under 149 about fake license, no license, etc. The onus would shift to us to prove our defense only after the owner, that is the respondent number 2, proves his case. Only after he pleads and proves that there was a license, there was an effective license, the pillion rider in this case was holding an effective license, nothing of that sort was done. So that is why I had highlighted the observation or the finding of the MACT that no evidence was led by OP number 2. Now, again, my lord, this fact of no evidence being led becomes crucial in the next paragraph, my lord. If lordship permits, I'll just read the underlined lines, my lord. It's a fairly big paragraph, so I'll read the underlined lines starting from the middle. Respondent 1, owner of the offending vehicle, did not produce any evidence except a driving license of one Joginder Singh, without any specific stand taken in the pleadings or in the evidence that the same Joginder Singh was in fact authorized to drive the vehicle in question at the relevant time. Only then would onus shift, requiring respondent number 2 insurance company to rebut such evidence and to produce other evidence to substantiate its defense. This is important, my lord. Merely producing a valid insurance certificate in respect of the offending truck was not enough for respondent number 1 to make the insurance company liable to discharge his liability arising from rash and negligent driving by the driver of his vehicle. The insurance company can be fastened with the liability on the basis of a valid insurance policy only after the basic facts are pleaded and established by the owner of the offending vehicle that the vehicle was not only duly insured but also that it was driven by an authorized person having a valid driving license. Without disclosing the name of the driver in the written statement or producing any evidence to substantiate the fact that the copy of the driving license produced in support was of a person who in fact was authorized to drive the offending vehicle at the relevant time, the owner of the vehicle cannot be said to have extracted himself from his liability. The insurance company would become liable only after such foundational facts are pleaded and proved by the owner of the offending vehicle. So there is I'm required to point this out humbly, my lord, that there is a popular perception amongst owners that because they are covered by an insurance policy, if there is an MACT claim, they are not required to participate or to take the headache of putting up any sort of defense, my lord. Supreme Court has changed that perception, my lord, in 2018 itself through this judgment, that the insurance company would become liable only after foundational facts are pleaded and proved by the owner of the offending vehicle. In this case, in our case, my lord, no such attempt was made.
What if the matter has proceeded ex parte and you have taken the defense of 170?
My lord, that is what I'm trying to highlight, my lord. The matter should not have proceeded ex parte. It was incumbent, as per the Supreme Court, it was incumbent on the owner to participate and to put up a valid defense, my lord, to plead and prove foundational facts, my lord.
Irrespective of that, proposition,
my lord,
that remains that, like you said,
my lord.
Since that is the common perception,
yes, my lord,
among owners,
yes, my lord,
that they're not required to appear and so on and so forth.
Yes, my lord.
They would still do it.
Yes,
still, do it, and then invariably the insurance company would take on their defense.
The defense, yes,
which means that they will step into their shoes.
True, my lord.
So.
Just two responses, my lord. First response would be the fact that matter had gone ex parte against the owner means that he received notice. Only then can the matter go ex parte. So once, as per this 2018 judgment, once you receive notice, you're required to participate in that. You cannot, as Supreme Court said, merely producing a valid insurance certificate is not enough. You have to plead and prove foundational facts, my lord. So number one, ex parte, it may have gone, but as I said, it should not have gone. The owner should have participated, which he did not. Number two, my lord, me taking over defense under 170 merely expands the scope of my defense. So for example, in cross-examination questions that I would not normally not be stopped from asking, I can ask those questions because I'm under 170 coverage, my lord. But the fact remains, my lord, as per the Supreme Court, that the onus is on the owner. The onus is on the owner to first produce evidence, to first adduce evidence, to first plead certain foundational facts. In this case, that did not happen. In this case, that did not happen. If Lordship allows, on the same page, there is this 1997 judgment which addresses this point, which specifically addresses this point that in case the owner does not come to the stand, then what happens? This United India versus Gyanchand 97 judgment, para 10 has been extracted, my lord.
Yes.
I'll read, my lord. We fail to appreciate how the aforesaid decision can be of any avail to learned counsel for the respondent claimants on the peculiar facts of the present case. It has been clearly held by the tribunal as well as by the High Court that respondent 1, who was permitted to drive the vehicle by respondent 9, the insured, was admittedly not having any driving license. It was not the case of respondent 9, the insured, that he did not know that respondent number 1, whom the vehicle was being handed over, was not having a valid license. In fact, this is important, my lord. In fact, once he did not step in the witness box to prove his case, an adverse inference has necessarily to be drawn against him to the effect that the vehicle had been handed over by him for being driven by an unlicensed driver, respondent 1. That finding reached by the tribunal as well as by the High Court must result in exonerating the insurance company of its obligation as the statutory defense becomes available to it. Lordship, I'll just reiterate this. Once, as per the Supreme Court, once the owner does not step into the witness box, an adverse inference has to be drawn against that owner, that he did not, or his driver or he did not possess any sort of driving license. And once that happens, my lord, the result is that the insurance company is exonerated from its obligation, from its liability. It is released from its liability, my lord. So in this case, the exact same thing has happened. In this case, the obligation or the onus was on respondent number 2 to bring evidence, to plead, to submit pleadings, to bring evidence. That duty was not discharged. That being the case, the result is that we are to be discharged, we are to be exonerated from liability in this matter, my lord. So there is a finding of policy violation, but in spite of a finding of policy violation, we have been saddled with the liability of making the payment and maybe later trying to recover it from the owner, from respondent number 2. But that, as I said, it's a Pyrrhic victory. It amounts to nothing in reality. What we have to go by is the law. The law is very clear that once you do not step into the witness stand, once you do not establish foundational facts, then there has to be an adverse inference drawn against you. The result of that adverse inference is to release the insurance company from any liability in this matter, my lord. That is my second ground, my lord, the fact that there is an admitted policy violation, admitted to the extent that MACT itself has observed that there is a policy violation. In view of the 2018 Pappu judgment, in view of the 1997 United India versus Gyanchand judgment, the picture is very clear, my lord. The picture is very clear. We have to be released from liability. We have to be released from liability. That is my second ground, my lord. Third ground, my lord, very short ground. This relates to the quantum, my lord. Now, as far as quantum is concerned, my lord, the MACT has found that the medical expenses of the victim, of the husband of the claimant, amounted to about 11,03,787 as per the observation of the MACT, my lord. For this, MACT has relied on Exhibit 3 to 31A. Looking at Exhibit 3 to 31A, my humble submission is that totaling all that, it does not come to 11,03,787. Unfortunately, my lord, I apologize for this. I'm not equipped with the exact figure at the moment, but in my synopsis, I'll give the exact figure. Awarded amount, whatever be the findings on the other grounds, awarded amount has to be reduced accordingly, my lord. It does not, the bills, invoices, etc., my lord, do not come to 11,03,787, my lord. Also, my lord, connected.
What is the degree of
my lord, if I can just point out the disability, there is no disability. There is no permanent disability. I'll just take lordship's attention to the paper book. Page 127, my lord. Page 127. This is again from the judgment itself. Page 127, para 118. There is no evidence that CW2 is permanently disabled, and the discharge summary exhibit so-and-so does not indicate permanent disability of CW2. But to answer lordship's specific query, the degree of disability, my lord, again, there is no evidence. There is no discussion also in the judgment, my lord. So he received injuries, definitely, but the degree of the injuries or the degree of disability he may have suffered, there is no material, and the finding is that he is not permanently disabled, my lord.
Does it warrant an expenditure of 12 lakhs or so?
There are bills, my lord, and we are not really in a position to dispute those bills, hospital bills. But my point is that those hospital bills do not come to 11,03,747, which the MSCT has observed is the total, my lord. Slightly connected point, my lord, is at para 116, same page.
Yes.
There was a amount awarded of 60,000 for loss of income. With regard to loss of income, CW2 stated that his income is rupees 25,000. But CW1 stated that she is not giving any salary to CW2. CW1 is the wife, the claimant. CW2 is the victim, my lord. She is not giving any salary to CW2, and CW2 is running the business in her name, and they manage whatever CW2 earned, they manage with that income. Since there is no supporting documents with regard to the income of CW2, his salary is then taken at rupees 10,000 per month. Now, with respect, I need to state this, my lord. The MSCT has randomly picked up a figure and said that this will be his salary. In a case where salary is not proved through any sort of material or documents or oral evidence, then the rule of thumb is that the notional income that is prevalent in the state at that time has to be taken, my lord. Now, this is a very well-established position of law, my lord. If lordship kindly looks at page 15 of the memo of appeal, 15, my lord. Page 15 of the memo of appeal, somewhere in the middle, my lord, Shanti Devi versus Bhagwan Das.
No citation given?
My lord, it's an unreported judgment, but I'll give a copy along with my synopsis, my lord. Para 8 and 9, my lord. I'll just quickly read, my lord. It is no more res integra that mere bald assertions regarding the income of the deceased are of no help to the claimants in the absence of any reliable evidence being brought on record. The thumb rule is that in the absence of clear and cogent evidence pertaining to income of the deceased, learned tribunals should determine income of the deceased on the basis of the minimum wages notified under the Minimum Wages Act. Very clear proposition of law, and it's an approach that normally most MSCTs follow, but in this case 10,000 rupees has been taken, I would say out of the blue, my lord, out of the blue. It should have been the Minimum Wages Act that should have determined the monthly income. That would come to about 6,000, my lord, not 10,000. There consequently 60,000 has been awarded for loss of income for the period he spent in the hospital. Because he spent, according to the MSCT, he would have suffered for about 6 months. So taking 10,000 as the per month salary, he's awarded 60,000 for loss of income. That has to be reduced, my lord. That has to be reduced. My last ground is on the interest part, my lord. Interest awarded is 8%. I am banking on lordship's judgment passed few days back in my appeal, Abdul Sattar judgment, my lord, where lordship has very correctly referred to the existing bank rates and reduced that interest from, I think it was 9% in that case, to 7%, my lord. In this case also, 8% has been awarded. I request that a reduction be made at least to 7%, if not less, my lord. It may appear to be a reduction of just 1%, but interest is applicable from 2014, my lord.
Okay.
So it amounts to a substantial sum, my lord. So if that is reduced also, it amounts to a substantial sum. So just to conclude, my lord, these are my grounds. Just to conclude, negligence had to be proved. The evidence on record shows there was a third vehicle involved. So how could you hold respondent number 2 as the negligent person, as the negligent party? In fact, the evidence shows that he himself was a victim in a way. He became unconscious along with the claimant's husband, and they were moved to the side of the road. So number one, negligence could not be proved, was not proved. The learned domesticity was wrong in coming to a conclusion that negligence is proved only because charge sheet is filed. What happens in a criminal court stays in a criminal court. It cannot be imported into the MACT proceedings, my lord. Number one. Number two, again, there cannot be a serious dispute about this. There is a policy violation. MACT has also concluded that yes, there is a policy violation. The law stipulated by Supreme Court says owner has to come and plead and prove foundational facts. Nothing of that sort was done. The moment again Supreme Court said,
who is the owner of the motorbike?
Responded to, my lord.
Okay, oh, he's
the owner plus the rider. Yes, my lord. Yes.
Okay.
He was my insured. He had taken my policy, and he was the rider.
He did not come to the witness stand.
No. He
should have. He is the injured.
Yes, my lord.
I said he should have.
Should have, my lord.
He was also injured.
That's my point, my lord. He should have, my lord. As per the Supreme Court, my lord. So the second point is on policy violation. The third is on the quantum, my lord. The injuries, the bills do not total to that 11 lakhs so and so. The exact figure, my lord, will kindly indulge me. I will supply in my synopsis, my lord. Loss of income 60,000 requires a slight reduction, my lord, because notional income should have been taken. Lastly, my lord, on the interest, a reduction of that 8% to at least 7%, if not less, is required to be ordered for, my lord. That's all.
May I please, Your Lordship? Your Lordship, my learned friend has raised as many as 4 grounds. In fact, in his appeal, he has raised several grounds, but he stick to only 4 grounds. So I'll answer to all these 4 grounds one by one, my lord. As far as negligence is concerned, my friend has said that he has taken your lordship to the evidence of CW3, who is none other than the investigating officer in this case, my lord. Now, he has read only those portions of his evidence which was in his favor. The one which is in my favor, he just left out. May I take your lordship to the paperwork compilation, page 38, that is CW3. Page 38.
Page 38?
Yes, my lord. Now, page 38, your lordship, I will not read the whole paragraph, whole page. I'll take your lordship to the second last paragraph, if your lordship has got that. As per the sketch map.
Yes.
As per the sketch map, I found the scooty as well as the bike was parked in corner of the roadside 2 meters away from the military gate. On analyzing the debris found in the place of occurrence, was 2 meters away from the military gate, total width of road number 12.70 meter. My lord, this line is important, and it was also evident that the bike bearing registration number so and so was in a totally wrong side. He has left out that point. Bike was totally in the wrong side.
Yes.
Now, this is the evidence of PW3, my lord. PW2, who himself is the victim in this case, he stated before the court in the box that he saw the bike hit him. At that relevant point in time, he was not unconscious. Before accident, he was not unconscious. He was conscious and he saw who has hit him. And especially when a bike hits from the head-on collision, my lord, not from behind. So he knew that a bike has hit him. And the theory of omnibus also does not find place in view of the evidence of the victim himself, who stood in the court and said that he saw the bike coming from the opposite direction and it hit him. Thereafter, he lost his consciousness. So that is very relevant point as far as negligence is concerned. Now, my lord, my friend has stated that CW3 has stated that there was a pillion rider, and he stated that they were hit by an omnibus. It was duty incumbent upon the insurer to bring that person to the dock to prove that this accident was not caused by this motorcycle, it was caused by omnibus. It is here and say that person never came to the dock. He was never brought, neither by the offending motorcycle rider nor by the insurer before the dock to prove that. It is here and say. The IO also, he did not file the charge sheet merely because that person has said that there was an omnibus involved in the accident. Not because of that. Because CW2 himself has stated, and in his investigation he found that the bike was lying in the wrong side of the road. Those are valid points, Your Lordship. Based on those points only, the IO has filed a charge sheet. Now, filing a charge sheet, my learned friend has said that does not amount to negligence. The evidence is very clear, my lord. The negligence is there. Apart from that, there is catena of decisions led by the Supreme Court, where the Supreme Court has stated that yes, merely forget about charge sheet, my lord. Only FIR filed is enough to prove negligence. Leave aside the conclusion of the trial. We are not going into the conclusion. Just FIR is also enough. I have got citations, I'll place it before this lordship. Now, as far as vital point, which he has also mentioned in his synopsis, that is breach. The whole case is lying on the breach. My submission to that, there is no breach, my lord. Absolutely no breach. They should be thankful to the tribunal. Learned tribunal has given them that much liberty to recover the money. In fact, there is no breach at all. If your lordship will see, when my learned friend has taken two rules, central motor vehicle rules, if your lordship will, I will request your lordship to revisit again section 3, rule 3, sorry my lord, of central motor vehicle rules.
Yes.
General, my lord, the provision of subsection 1 of section 3 shall not apply to a person while receiving instructions or gaining experience in driving with object of representing himself for a test of competence to drive, so long as, A, your lordship, such person is a holder of an effective learner's license issued to him in Form 3 to drive vehicle. Now, relevancy is, my lord, B. Such person is accompanied by an instructor holding an effective driving license to drive the vehicle, and such instructor is sitting in such a position to control or stop the vehicle. Now, my lord, I will take your lordship to the proviso to this too. Provided that a person while receiving instructions or gaining experience in driving motorcycle, my lord, motorcycle,
Yes.
with or without sidecar attached, shall not carry any person on the motorcycle except for the purpose and in the manner referred to in clause B. Now, he should not carry any person except for the purpose of clause B. Now, I'll take back your lordship to clause B. Now, clause B says that such person is accompanied by an instructor holding an effective driving license to drive the vehicle, and such instructor is sitting in such a position to control or stop vehicle, my lord, not motorcycle. It says vehicle, and he is indicating motorcycle.
But in any case, you see, the proviso says, in the course of driving a motorcycle. So it refers to clause 2, which means that not only vehicle, but also
Now, I will satisfy that point, my lord. Now, what is the logic of an instructor? Now, if a motorcycle, your lordship has seen a motorcycle. In a motorcycle, my lord, the entire control of the motorcycle is in the hand of the rider. Brake, clutch, accelerator, everything, steering, even balancing is with the rider alone. Now, the logic behind putting an instructor is to control the vehicle if the learner makes any mistake. How on earth he will be in a position to control that if a learner makes a mistake? He has no control. He is sitting behind. He has no control over brake, he has no control over steering, he has no control over accelerator or the steering. So how will he control? Logically, there is no need for an instructor in a motorcycle. Now, my lord, exactly identical case has been decided by Kerala High Court. Identical, facts identical. I'll place it before your lordship, wherein it has been clearly stated that this instructor is only required for four-wheeler. My lord, I will take your lordship to Rule 24 of Central Motor Vehicle Rules. Rule 24, my lord.
Yes.
Clause 5. The vehicle are available exclusively for the purpose of imparting instructions, and all such vehicle except motorcycle are fitted with dual control facility to enable the instructor to control or stop the vehicle.
Just a moment.
My lord. Rule 24.
Yes.
Rule 24, your lordship has got?
Rule 24.
Yes. 1. No person shall establish or maintain.
Driving school and establishment.
Yes, my lord. No person shall establish or maintain any driving school or establishment for imparting instructions for hire or reward or in driving motor vehicles without a license in the form 2 granted by the licensing authority. My lord, will come to 5, clause 5 of the same rule, my lord. 5. Your lordship has got that 5?
Yes.
Yeah. The vehicles are available exclusively for the purpose of imparting instructions, and all such vehicle except motorcycle, my lord, are fitted with the dual control facility. Your lordship has got that?
This is the explanation. You are referring to the
explanation, my lord. Explanation, yes. Explanation 5.
Rule 3, sub-rule 5. Sub-rule 3,
yes.
24, 3, 5.
Yes, 3, 5.
Yes, my lord.
But not because 5 is another
Clause 5, my lord.
Okay.
The vehicles are available exclusively for the purpose of imparting instructions, and all such vehicles except motorcycle are fitted with dual control facility to enable the instructor to control or stop the vehicle. So, instructor is required in a vehicle, and that too in a vehicle where there is a facility of dual driving. The instructor can sit and control the vehicle. In motorcycle, it is not there, my lord. Even if it is, presumably, the pillion rider has a effective driving license, what can he do? Can he control the vehicle if anything goes wrong? Does he have any control? But in vehicle, he can do. Because there is a facility, brake, clutch, accelerator, everything is there under his control. So as also with the driver. So logic is there, that instructor in a vehicle, yes, justified. Not in motorcycle, my lord. There is absolutely no logic, and law is also very clear. It says, Rule 3 clearly says, my lord, only in the vehicle, not in motorcycle. Now that judgment, I'll place it before your lordship. Now coming to the other point, your lordship.
While you're on this point, you refer to the judgment.
Judgment I have, my lord.
You've made a compilation?
Yes, my lord. I'll take your lordship to this page number 39. Page number 39, running page, your lordship. This is a judgment from Karnataka High Court. page number 39. This is the judgment. The relevant paragraph, my lord, will be at page 46, para 10. Page 46, para 10, my lord.
Not reported.
It is reported, my lord.
Where's the citation?
No, my lord, it is not reported, perhaps. My lord, para 10. Learned counsel appearing for the appellant insurer has vehemently contended that at the time of
Just a minute, please.
my lord, para 10.
Let me note down. Yes.
Para 10, my lord. Learned counsel appearing for the appellant insurer has vehemently contended that at the time of accident in question, the rider of the motorcycle, that is respondent number 1, had no valid license to drive motorcycle and he was holding only learner's license. As per provision of Motor Vehicle Act 1988, for short, the Act, a person who holds learner's license should take instructor along with her. However, here in this case, the deceased was a pillion rider on the motorcycle which was rode by the respondent number 1 who was not having driving license. Instead, she had only learner's license. She was supposed to learn the driving or riding motorcycle with the instructor. As per provision of Rule 1 of Rule 3 of Central Motor Vehicle Rules 1989. She has to mention the English letter L on the motorcycle, and without instructor, riding of the motorcycle by a learner would amount to violation of condition of insurance policy, and there is a fundamental breach in the terms and condition of the policy. But the tribunal committed an error in fastening the liability on the respondent insurer, and the liability ought to have been fastened on the owner of the motorcycle, but the same was not fastened by the tribunal and wrongly held in this insurer is also liable to pay compensation. So this was the case of the insurer, my lord. Now the findings of this case, my lord, your lordship may kindly come to page number 59. Page 59. Para 23, your lordship. As per Rule 24 of Rules, it defines about the establishment, which I read just now, your lordship, that Rule 24 of Central. As per Rule 24 of Rules, it defines about the establishment of driving schools and qualification of instructor. Rule 24.3.5 of the rules define as follows. The vehicles are available exclusively for purpose of imparting instruction, and all such vehicle except motorcycle are fitted with the dual control facility to enable the instructor to control or stop the vehicle. Para 24, my lord. On bare reading of 24.3.5 of the rules clearly provides that the instructor shall accompany with the learner while driving the motor vehicle, having dual control facility to enable the instructor to control or stop the vehicle. Whereas the motorcycle was excluded or exempted and it does not require the instructor to be accompanied. However, Section 3 of the Act defines necessity of driving license. Provided to Rule 3 enables the rider of the motorcycle shall not carry any person on motorcycle as pillion rider except for the purpose and in the manner referred to in Clause B, which shows the person holding driving license shall be accompanied with a person who holds a learner's license for motor vehicle, not for motorcycle. This is what I was trying to say, my lord. Not for motorcycle. Motor vehicle, my lord. Rule 3, Section 3 clearly says for motor vehicle, not for motorcycle. This is what this judgment says. Then the next conclusion, my lord, comes at page 65. Page 65. This is the conclusion of the case, my lord.
Yes.
If your lordship has, please. On the other hand, in view of the principle laid down by the Honorable Apex Court, as well as Honorable High Courts in the case of Mandar Madhav Tambe, so and so, was Sheila Devi and others, and Shivpal Singha, the license held by the respondent number 1, even though it was a learner's license, but it is a valid license. Therefore, it cannot be said that there was any violation of the terms and conditions of the insurance policy. Even Central Motor Vehicle Rules strictly contemplates accompanying of an instructor in a motor vehicle but excludes the motorcycle. Therefore, I hold that a learner license is also a valid license. The rider or the learner need not accompany any instructor for motorcycle as required in the case of four-wheeler vehicle. Motor vehicle, which requires instructor. Therefore, the contention taken by the insurer that the respondent number 1 was not holding a valid driving license and she was holding only learner's license to ride a motorcycle on the road cannot be accepted. The tribunal, later considering the evidence on record, has rightly concluded that the learner's license held by the respondent number 1 is a valid license and has rightly fastened the liability on the insurer. Therefore, the findings of the tribunal regarding fastening of liability on the insurer does not call for any interference by the court. Hence, I answer the point number 1 in favor of the claimant and against the insurer. So, where is the breach, my lord? There is no breach. Even if it is presumed that the learners, because if they have taken the plea, my lord, this is a settled position of law. Your lordship has already discussed this in Swaran Singh case. Your lordship has relied on that. In 2024, your lordship has disposed on MSC case where your lordship has relied on Swaran Singh case. Clearly mentions, your lordship, that if a plea of breach of policy is taken by the insurance, he has to stand in the dock and prove it with cogent evidence, not simply by taking the plea that there was a breach. Here, no evidence has been led from the insurer, nor from the opposite party number 2. No evidence has been led. Yet, now they are relying upon the findings of the tribunal. Tribunal has said that there is a breach of policy. Now, how the tribunal has reached to that? Tribunal has simply presumed, my lord. When the tribunal has said that there is no evidence. So, tribunal presumed under section 114 of Evidence Act that since there is no evidence, there is a breach. Otherwise, the insurer did not bring any evidence in the court to prove that there was a breach. And this breach was deliberately caused by the insured. That evidence should have come. Swaran Singh clearly states about that. That judgment also I have annexed in my citations, my compilation, my lord. I'll come to that later on. Now, clearly, my lord, they have neither proved that there was a breach, nor your lordship has established my lord, they have also not annexed the copy of written statement. Written statement was filed by OP number 2. He appeared in the court. He cross-examined my witnesses. He appeared in the court. He filed his written statement. He also cross-examined my witness. Thereafter, he started absenting. And the matter proceeded ex parte. So he has filed his written statement, which is not a part of the record, my lord. Of course, your lordship has called for the lower court's record. It must be there. But in the memo of you, they have not annexed. It is there. In para 19, they have clearly admitted, sort of admitted, my lord, that the accident took because of them. If I am allowed to read, your lordship, para 19 written statement, para 19 of the written statement, which is not there, my lord, it will be in the lower court's record. They have not annexed with the memo of appeal, nor they have annexed in the. So perhaps if I just read it, just to show your lordship can peruse it in the case record.
Yes, yes.
With regards to the statement made in para 16 of the claim petition.
WS of?
This is WS filed by the opposite party number 2, my lord. Amit Kumar Saha.
Okay. He is
the rider of the offending motorcycle, my lord. With regards to the statement made in para 16 of the claim petition, the answering opposite party denies the statement, which is totally false. In reply, the answering opposite party begs to state that the claimant fully knows that the opposite party was not in a position to pay their demands and request to settle the matter amicably by taking reasonable amount. He is admitting.
Para?
He is admitting, my lord.
Para?
Para 19.
19.
Yes, my lord. Amicably by taking reasonable amount and to do his treatment in civil hospital Shillong. To do his treatment in civil hospital Shillong. And then he would be ready to pay. What does it mean, my lord? He's admitting that he's caused the accident. Otherwise, why will he go and approach
Yes.
the victim?
Yes.
Civil hospital. But the claimant, without knowledge of the opposite party, did the injured person treatment in some private hospital without the advice of civil surgeon of civil hospital Shillong. So admittedly, in para 19 of their written statement, they have admitted that their accident has been caused. Otherwise, there is no question for them to go and compromise. So negligence is there, my lord. It is proved by cogent evidence, evidence by CW2 and CW3. Properly appreciating that evidence, the court has come to that conclusion that there was a negligence on the part of the offending, the opposite party number 2. And that is how the tribunal has reached to this conclusion, my lord. Now, coming to the point of quantum, my lord. As my learned friend is saying, he has not said anywhere that where is the mistake. The calculation has been done by the court. I have exhibited all the medical bills. In fact, medical bills, hospital bills, hotels bills, flight tickets, helicopter tickets, conveyance, everything I have exhibited before the court. Court has calculated this amount and reached to this about 11 lakh something. Compensation has not been paid to me, only 1 lakh something odd, my lord. Otherwise, the entire thing, quantum is my medical bill. Only some few amount of 1 lakh something has been paid for 10 days. Now he's saying that the amount of my income also should be reduced. Now I am not that amount which he has placed before this court, 6,000 rupees, is meant for laborers, workers, daily wage workers. I am a businessman. I run a shop. It has come in the evidence. I run a shop, my lord. Now I am a businessman. My salary will be 6,000 rupees per month. At least minimum the court has found it reasonable. That 10,000 amount was reasonable enough to grant. I have asked for 25,000, court did not give. Only 10,000. Yet they are not satisfied with that, my lord. And as far as interest is concerned, my lord, interest calculation, my lord, at that relevant point of time when the claim application was filed, it was in the year 2015. 2015, the saving bank interest was 7% and FD was 10%, my lord. Now, since then, the interest has to be calculated from the date when I filed the application. Now, how that interest will be reduced from the present date? If the present date, the rate of interest is reduced, can it be applicable in my case, my lord? 2015 I filed it. And after such a long delay, I have got something. That too they want to reduce. The interest was given how much, my lord? Only 8% by the tribunal, which is not high at all. In this judgment which I have that Karnataka High Court, my lord, here also same thing has been raised about interest and has been settled in this judgment. If your lordship will go to the last paragraphs, everything is there. Now coming to the point, your lordship, of pay and recover liability. They should be very happy that pay and recover liability was given by the trial court, my lord. Now, my lord, I will take your lordship to page number 37 of my compilation. This is the judgment of Supreme Court which your lordship has relied in many decisions. Swaran Singh, Supreme Court, landmark decision, my lord. Page 37, para small 3, my lord. 37, if your lordship has got, I have marked it.
This is the judgment?
My lord, this is the judgment, Swaran Singh.
Para?
Para 3, my lord.
3.
Small 3.
This is small 3.
Small-
Where's the main part?
Main part of this,
Where's this? This is not a complete judgment.
my lord, this is actually legal. I have got this from AIR also, my lord. AIR also I have got,
See, always remember when you cite a judgment,
my lord.
you have to give the citation from the recognized journals. Legal, Indian Kanun and all, they will not do.
My lord.
Because more often than not, we have noticed there are some mistakes.
My lord.
So
I will,
perhaps that may not be.
I'll provide this judgment from AIR, my lord.
Yeah.
Yeah.
Yes. AR 2004.
My lord. If your lordship will come to page number 1557,
Para?
para 105. Para 105, my lord.
105. Yes.
Lordship has got that.
Yes.
105(3), sub clause 3, my lord.
Yes.
The breach of policy condition, example, disqualification of a driver or invalid driving license of the driver, as contained in subsection 2A, clause 2 of section 149, have to be proved to have been committed by the insured for avoiding liability by the insurer. Mere absence, fake or invalid driving license, or disqualification of the driver. Your lordship, our case is falling under disqualification as per the allegation that I was disqualified since there was no instructor. Since there was no instructor, so I was disqualified to drive.
Okay.
So it comes under or disqualification of driver for driving at the relevant time, my lord,
Yes.
are not in themselves defenses available to the insurer against either the insured or the third parties. To avoid its liability towards insured, the insurer has to prove that the insured was guilty of negligence and failed to exercise reasonable care in the matter of fulfilling the condition of the policy regarding use of the vehicle by duly licensed driver or one who has not been qualified to drive at the relevant time, my lord. Now next paragraph, next page, your lordship, will come to paragraph 8. 8, your lordship. If a vehicle, your lordship has got that?
Yes.
If a vehicle at the time of accident was driven by a person having a learner's license, the insurance company would be liable to satisfy the degree. Now 10, my lord. Where on adjudication of the claim under the Act, the tribunal arrives at a conclusion that the insurer has satisfactorily proved its defense in accordance with the provision of section 149(2), read with subsection 7, as interpreted by this court above, that tribunal can direct that insurer is liable to be reimbursed. Now here, my lord, that is only when they prove it before the court that yes, a breach has taken place. They have to prove it by bringing in a witness in the witness box and saying that yes, the insured has done the breach. When they succeed in doing that, then, my lord, they will be given a liberty to recover it from the insured, not otherwise. So here, my lord, even if it is presumed that there was a breach, still, my lord, they are liable. They have to pay me first and then can recover it from the opposite party, number 2. That is the law, which is very clear in this judgment, my lord. And your lordship has relied on this judgment in this my compilation I have provided, my lord, at If your Lordship will come to page 73. Page 73. New India Assurance Company Limited versus Drusilla Mauro and others. Here in page 80, my lord, paragraph 36, page 80, paragraph, page 80, my lord, paragraph 36. Lordship has come to paragraph 36.
Yes.
Of the authorities cited by the learned counsel for the respondent number one found relevant by this court is the case of Suran Singh, wherein the principle of pay and recover later would apply to the present case, since there was no dispute that the claimant respondent number one are entitled to award of the compensation as directed by the learned tribunal. And since the appellant insurance company has raised the issue of invalidity of the policy in question, even if this aspect is considered, it would be incumbent for the insurance company to satisfy the award and to recover the same from the owner and the driver of the offending vehicle following the due process of law. So, my lord, here your lordship has referred to same paragraph which I have read, paragraph 104 and 107 of the said judgment. I would not like to repeat it, but I have marked it, my lord. I have marked it. So your lordship has relied on that judgment. Now coming to the next judgment, my lord, that is Pappu, what he has referred. Pappu, that judgment is also here, my lord, Vinod Kumar. And Gyan Singh, which he has stated, my lord, in Swaran Singh itself has said that this judgment, my lord, in Swaran Singh's judgment, because I have to look from, is not applicable in this case, my lord. The facts are distinguishable. I will come to it later, my lord. I will just take your lordship to this Pappu and others, Vinod Kumar Lamba. This is cited in AR 2018 Supreme Court. It is their judgment which they have mentioned in their memo of appeal. This is at page number 82. Page number 82, para, my lord, para 88 and 89. Page 88, my lord, para 110. Page 88, para 110. If your lordship has got.
Yes.
Chapter 11 of the Motor Vehicle Act 1988, providing compulsory insurance of the vehicle against third-party risk, is a social welfare legislation to extend relief by compensation to the victims of accident caused by use of motor vehicle. The provision of compulsory insurance coverage of all vehicles are with this paramount object, and the provisions of the Act have to be so interpreted as to effectuate the said object. Number 2, insurer is entitled to raise defense in claim petition filed under section 163 or 166 of Motor Vehicle Act 1988, inter alia in terms of section 149 2A2 of the said Act. The breach of policy condition, example, disqualification of driver or invalid driving license of the driver, as contained in section 2A2 of 149, have to be proved to have been committed by the insured for avoiding liability by the insurance. Mere absence, fake or invalid driving license or disqualification of the driver for driving at the relevant time are not in themselves defenses available to the insurer against either the insured or the third parties. To avoid its liability towards insured, the insurer has to prove that the insurer was guilty of negligence and failed to exercise reasonable care in the matter of fulfilling the condition of the policy regarding use of vehicle by duly licensed driver or one who was qualified to drive at the relevant time. The insurance company are, however, with a view to avoid liability, must not establish the available defenses raised in the said proceeding, but must also establish breach on the part of the owner of the vehicle, the burden of proof wherefore would be on them. Now, they are only relying on one line which has been stated in the judgment, impugned judgment, my lord, that the tribunal has said that there is a breach of policy. Now, how the tribunal has come to that conclusion, my lord? Not on evidence, only on presumption. They cannot take that plea. They have to stand in their own feet to prove that insured has violated the policy. That has been not been done. Now, as far as my learned friend also said about that FIR, my lord, in this compilation I have given a judgment. If your lordship will come to page 91 of Supreme Court, this is online, my lord. This is a recently 2025 order, this year, page 91, your lordship.
Yes.
If your lordship has come to that page.
Yes.
Page 91, para 4, my lord. It is settled law that once a charge sheet has been filed and the driver has been held negligence, no further evidence is required to prove that the bus was being negligently driven by the bus driver. Even if the eyewitnesses are not examined, that will not be fatal to prove the death of the deceased due to the negligence of the driver. Now, this is settled position, my lord. Now, in my case, I don't need to take the shelter of this judgment. Why, my lord? Because the victim himself has stood in the box, witness box, and he stated that it was the motorcycle which came and hit me, not omnibus. And so far as omnibus is concerned, my lord, that is a concocted story. The story made by the pillion rider to escape the liability of the accident. It was never proved. The IO never brought him before the court, nor made him a witness in the criminal case. Now, criminal case is proceeding, my lord, before GMFC Shillong. It is in the stage of evidence. Accused is absconding. Warrant has been issued against him. My victim, he has been examined before that court already. So I am not going to see what my learned friend has said, that the conclusion of the criminal case cannot. I am not saying that. What I am saying that there is enough evidence on record to show that the motorcycle, the opposite party number 2, was negligible. He has committed this accident, and the victim himself has stated, corroborated by the PW3, when he found the bike in a wrong side. If it was not the bike, it couldn't have been in the wrong side. Sketch map is also there, my lord. Sketch map was drawn by the IO concerned. So my humble submission, considering all this aspect, there is no merit in this appeal, my lord. There is no merit. The appeal deserves to be dismissed with cost.
Lordship, if I can take 3 minutes, my lord, just to...
We'll take it up on the next date.
Very well. In that case, because these are very short responses, I'll cover them in my synopsis.
Then I will be also filing my synopsis if they file it.
And if I can request my friend for a copy of this compilation,
No judgment. I have given the name. I'll give the name.
I'm at a loss.
I'll give the name of the judgment.
He has to respond to your authorities.
Swaran Singh, my lord.
We'll take it up. We'll continue on the next date. Since you will have to at least
synopsis, you'll file it. Synopsis. So let him file, my lord.
Convince the court that the authorities cited by him are not relevant.
Very well. I'll do that.
So in a synopsis, that would not do.
Very well.
So that will come later.
I'll do that.
My lord.
Heard Mr. S. Tindal, counsel for the appellant. Also heard Mr. L. Mansuri, counsel for the respondent number 1.
My lord.
You're respondent 1?
No, I'm... yes, respondent number
1. Hearing is not concluded and will continue on the next date fix. This is matter after 3 weeks.
Obligement.
Any mention?
Lordships, I beg to mention item number 5. Afraid that the matter may come up after vacation, Your Lordship. Puja vacation.
On premier with the appellant, this is matter after 3 weeks.
Please, Your Lordship. Lordship, I beg to mention item 8, Your Lordship.
9 or 8?
9, Lordship.
Come after 3 weeks, then, Your Lordship.
3 weeks.
Apply, Your Lordship.
Lordship, item 9 as well, Your Lordship. Item 9 as well. Similar prayer, Your Lordship.
No objection, my lord.
Joe, same order.
Hello,
3 weeks.
May it please, Your Lordship, I beg to mention item number 6.
6.
Yes, number 6, sir.
3 weeks.
Yes, my lord. Highly obliged, my lord.
Tiki Kerting, Tiki lawyers, black and white.
Your Lordship, I beg to mention item number 13. Kindly pray for the 2 weeks times since Learned Council is out of stations.
So 2 weeks. Same order. 2 weeks.
Highly obliged, you.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 12, Your Lordship. Pray for 2 weeks' time, Your Lordship.
2 weeks. 12 more.
Can they release item number 1?
Lordship, this is an appeal which is filed by the aggrieved party against the judgment of acquittal of the accused. Now, initially, this appeal was also filed with an application for seeking leave of the court to file such appeal as it was required. Now, during the course of hearing of that petition, a judgment came into the light of 2025 in the month of July, by which the apex court has held that in the case of appeal by the aggrieved party, no permission is needed. In that view of the matter, my application became infectious and it was not pressed, and delay was condoned. Delay was condoned thereafter, and now the matter is listed for admission. On the last occasion, at the stage of admission, my learned friend appearing for respondent number 2 and 3, that is those who were accused in the case, he has made a oral submission that my appeal is not maintainable. So he has to begin that, show that how and in what, there is no written application filed by which I can come to know that on which ground they are opposing my applications, that it is not maintainable. So, Your Lordship, I will humbly request, let him prove or let him make his submission that this appeal is not maintainable. Then I will proceed.
Yes, Mr. D.
My lord. My lord, this is an appeal which has been filed by my learned senior for the Apex Bank, my lord. If my lord may kindly come to the cause title of the appeal, it's in page 1. My lord may kindly see in the matter of an appeal under section page 1, my lord.
Yes.
Page 1. In the matter of an appeal under section 4191B, read with section 413, my lord,
Yes.
of BNSS. Now, if and learned senior is before this honorable court, my lord, against the order of the trial court which has acquitted me, and against the order of appellate court, session court, my lord, which has dismissed the appeal of the state, my lord. They were before the session court, my lord. They have not even taken a pain to go to the session court. Now, my lord, if my lord may kindly see 419, if my lord may kindly see the BNSS 419.
BNSS. This is BNS, no? Yes.
My lord may kindly see under section 4191B, my lord senior has filed this appeal.
Yes.
Now, B says, my lord, the state government may, in any case, direct the public prosecutor to present an appeal to the High Court from an original or an appellate order of acquittal passed by any court other than a High Court, not being an order under Clause A, or any order of acquittal passed by the Court of Session in revision. Now, this clause is not applicable, my lord. This provision itself is not applicable, my lord, for the victim to come before this honorable court, my lord.
Yes.
This is my first limbs of argument, my lord. And if 419, my lord, if my lord senior comes under 419, my lord, then leave will be required, my lord. Now, my lord may kindly see clause 3 of 419.
Yes.
No appeal to the High Court under subsection 1 and subsection 2, my lord. So, we was concerned about 1B, my lord. And subsection 2 shall be entertained except with the leave of the court. So, if my lord senior is coming under 4191B, my lord, then leave is required, my lord. And leave was not taken by this honorable court, by this court, my lord. Leave was not granted. Now, my lord may kindly see now, my lord senior has also come under, because probably the bank was confused under what provision they should come, my lord. That is why they have come with 4191B read with section 413. Now, my lord, if my lord see 413, what it stipulate?
Yes. 413.
413, my lord. No appeal shall lie from any judgment or order, if my lord got it, my lord.
Yes, yes.
No appeal to lie unless otherwise provided. That means, my lord, no appeal shall lie unless the court provide, my lord. Now, my lord, it says, no appeal shall lie from any judgment or order of a criminal court except as provided by this Sanathan or by any other law for the time being in force. Now, proviso has been added, my lord, in this. Now, they says, my lord, no appeal shall lie unless, my lord, there is a provision under which they can come, my lord. Now, proviso says, my lord, provided that a victim shall have the right to prefer an appeal against an order passed by the court acquitting the accused or convicting for a lesser offence or imposing inadequate compensation, as such appeal shall lie to the court to which an appeal ordinarily lies against the order of the conviction of such appeal. Now, my lord, it says the proviso, by adding this proviso, my lord, a right was given to the victim that you have the right to go and file an appeal to the court where the appeal ordinarily lies, my lord. It is not that the appellant has a choice, my lord. If the trial court has passed an order, my lord, acquitting the accused, my lord, then it is the session court, my lord, the hierarchy of the courts, my lord. It cannot be bypassed, my lord. Now, the appellant, my lord, has not gone before the session court. Who was the acquitting court, my lord? It was the trial court, magistrate first class. An appeal lies before the session court, my lord. Now, before the session court, the appellant was not there, my lord. State has gone and state appeal was dismissed, my lord. They was very much aware that that appeal doesn't lie before the High Court by the victim directly. They have written a letter to the state government to prefer an appeal against the order of dismissing the appeal by the session court, my lord. This letter which they have enclosed with their appeal, my lord, is there, my lord, in page 171, my lord. Annexure is not visible, my lord, so don't give the annexure. It appears to be 12, my lord, annexures.
Yes, annexure 12.
Annexure 12, my lord, 171 page. Subject, my lord, I will just read the subject. They have written to the law department, my lord. Filing second appeal against the acquittal dated so and so, passed by the district and session judge William Nagar in criminal appeal number 1 of 2024. They themselves, they are saying, my lord, it will be the second appeal. Now, whether the victim has the right to file a second appeal directly before the High Court, according to my understanding, my humble understanding, my lord, no. Because, my lord, 413 is very, very clear, my lord. It is the hierarchy of the court has to be followed, my lord. It cannot bypass, my lord. Now, if my lord may kindly see once again the proviso, my lord.
Yes.
Now, my lord may kindly see the proviso again, my lord, I will read. Provided that the victim shall have a right. My lord, got it again?
Yes.
Provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting. The word which I will emphasize is this, my lord, is acquitting. Session court has not acquitted me, my lord. Session court has not acquitted me. They have dismissed, session court has dismissed the appeal of the state, my lord. It is the trial court, it is the CGM who has acquitted me, my lord. If they are aggrieved, my lord, the appeal can go before the session court, my lord. Now, my lord, may kindly see the accused or the convicting for a lesser offence or this. And then they said, my lord, and as such, appeal shall lie to the court to which an appeal ordinarily lies. My humble understanding is this, my lord, the appeal will lie before the session court, my lord. Now, they have not taken a chance before the session court, my lord. They have come after the appeal of the state has been dismissed, my lord. They could have very much participated. They could have also filed an appeal, my lord, on their own grounds, whatever they feel feasible, my lord, for them. They have not done it, my lord. They have waited till the appeal is dismissed. Now they are before this honorable court, my lord. For thus, it appears to be a second appeal, my lord. Whether second appeal is permissible or not, my lord, that my lord has to decide, my lord. I will rely on one judgment, my lord, of Madhya Pradesh High Court. Probably, my lord, that may not be a bearing, but it will enlighten, my lord, that why, my lord, they cannot come direct to the High Court. The hierarchy of the court has to be followed, my lord. It's okay, I have. If my lord may peruse para 13 of page 4. Para 13, my lord. If the victim opt, they are the victim, my lord. Even though there is no statement made in the appeal, my lord, they are the victim. Still, they are claiming that they are the victim, my lord. If the victim opt, only 13.
Para?
Para 13, my lord.
Yes.
If the victim opt to approach the police authority and the court has taken cognizance on the basis of the final report, that means an FIR was lodged, my lord. Final report submitted under section 173. The relevant section is now, my lord, 413, my lord, of the code, and the case result in an acquittal. The victim, as a matter of right, may prefer an appeal against the order acquitting the accused, and such an appeal shall lie to the court to which the appeal ordinarily lies against the order of conviction of such appeal, my lord. So this is the legal position, my lord. Even though, my lord, we don't have a direct judgment, I cannot find it, my lord, a direct judgment on this subject, my lord, of the Supreme Court, but this is which will enlighten us, my lord. So it is basically, my lord, they are interpreting that it is the court before which the appeal should ordinarily lie. Now, my lord, the senior has to satisfy this honorable court, my lord, that directly they can file an appeal before this honorable court by bypassing the session court, my lord. According to my understanding, my lord, this petition itself is not maintainable. On two ground, one, I have shown, my lord, to proviso permit them to file an appeal before the court where the appeal lies, my lord. And if my lord may kindly see the cause title again, my lord, they have also come under section 419. 419 is not at all applicable, my lord. That is why they themselves, they was not sure, my lord, under which provision they should come. That is why they have come under 419 1B. 1B is for the state government, my lord. I have read it, my lord, and it's very clear. And if they comes under 419, my lord, then, my lord, a leave will be required, my lord. The statute itself provide that a leave has to be granted, my lord. Leave was not taken. And first and foremost, my lord, they also has to say, my lord, under which provision they are coming. 419 or 413, my lord. 419 and 413 is two different subjects altogether, my lord. That cannot be combined together, my lord, to grant, to get a relief, my lord, from this honorable court. So, my lord, according to my understanding, my lord, this is not maintainable at all, because 413, if it is 413, it is the code where the appeal should ordinarily lie. They have to approach, my lord. And if it is under 419, my lord, then a leave is required to be taken, my lord. That is my humble submission, my lord. Only on maintainability, my lord, I am submitting now.
Chief, the first point which is raised is that there is a wrong quoting of section in the cause title. Your Lordship is well aware that citing of wrong section doesn't take away the right. In fact, I will satisfy your Lordship that there is no misquoting also. However, your Lordship will find, as is submitted by the respondent number 1 and 2 also, that section 4191B is not applicable. This is admitted. But section 413 is applicable. Now, your Lordship, I just take to...
See, Mr. General, you are saying section 419 1B is not applicable.
Not applicable.
In spite of that, you have quoted that.
Yes, despite that it was quoted, and my submission is that misquoting of a section...
So you are not relying on it?
I don't rely on this. My appeal is only under 413. Your Lordship will come to the 413.
no appeal to lie unless otherwise provided. No appeal shall lie from any judgment or order of a criminal court except as provided for by this Sanhita or by any other law for the time being in force. So there is no quarrel on that there is no general right of appeal. The right of appeal must be provided somewhere. Now, this was the earlier position, and thereafter section 413, the CRPC section is 372. I'll show section 372 also. Proviso was added, and this proviso is added only to safeguard the interest of the aggrieved party or victim. And this proviso says, provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offence or imposing inadequate compensation, and such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. Now, Your Lordship, this proviso is applicable in my case, and this proviso gives absolute right to the victim. Victim stands on the same footing as that of the accused. Presently, formally, victim was also required to come to the High Court and seek leave of the court for filing appeal. Now, this appeal can be filed by the victim against both the acquittal order by the trial court as well as the appellate court order. Now, state has filed the appeal against the acquittal order passed by the trial court. State has got a right to file, they have filed it. Now, the district and session judge confirmed the finding of the trial court, and I have filed the appeal against the acquittal order of the trial court as well as confirming as well as of the appellate court which has confirmed the judgment of the trial court. Because I am a agreed party, and I have stated in my application also that agreed party has got a special privilege. Now, in view of this proviso, I am not required to take any leave of the court. Now, I will that the victim has got a right to file the appeal both against the trial court order acquitting him as well as the appellate court order. Your Lordship, judgment. Before that, Your Lordship, I'll just point out the CRPC also. The corresponding section of CRPC is 372.
I think there's no quarrel there. CRPC is no longer invoked now.
CRPC,
now we are going by
it's a procedural law.
Now we're going by the BNSS.
No, but for the purpose of interpreting the law laid down by the courts, higher courts, is still applicable. That would be referable only to the
relevant period.
Yeah, relevant period.
Before 1st July.
Yes,
So
Lordship.
we are not.
Lordship. Then I am referring to the judgment of a Bombay High Court. Bombay High Court, and I am taking to your Lordship paragraph 23. Lata Ramesh More. Lata Ramesh More. Paragraph 23. In view of the aforesaid reason and in keeping with the policy of the court and the intention of the legislature, it is necessary to interpret the expression such order of acquittal. Your Lordship, such order of acquittal found in subsection 4 of section 378 of CRPC so as to be understood as original or appellate order of acquittal. This order, your Lordship, is both, it can be original order or it can be a appellate court order. To say that a victim has got a right only to file the appeal against the original order only and not against the appellate court order is taking away the right of the victim, because Supreme Court even, I refer to that Supreme Court judgment which I have earlier referred, but that bench was different. This is Messrs. Calstium Financial versus A. Ganesh Karan, etc. Special leave petition. The copy is already there. Your Lordship will come to. This was decided on 8/4/2025, paragraph 5.1 onward.
Order dated.
This is the judgment dated 8/4/2025. Para, your Lordship, I am just giving. Para 5.1. Taking note of the aforesaid report, your Lordship got it? Internal page 13 of the report, 1-3. Last para, yes. 5.1. Taking note of the aforesaid report, an amendment was brought to the section 372 of the CRPC with effect from 31/12/2009 by adding a proviso thereto. The decision of the full bench of the High Courts in the matter of interpretation of the proviso to section 372 of the CRPC are highlighted by this court in the case of so and so. There are also division bench decision of the High Court taking a different view. So different views were taken by different High Courts with regard to the proviso which was added. Then 5.3, your Lordship, discussed the this court in Mallikarjun Kodagali speaking through local justice.
What was the proviso?
Proviso, Your Lordship, that provided that the victim shall have a right to prefer an appeal against any order passed by the court. Here, Your Lordship, phraseology is used, any order. And Bombay High Court say it may be a order of the acquittal by the trial court
or appellate court,
or even of the appellate court. Your Lordship, 5.3. I am reading the last 3-4 lines. It is quite clear to us that a victim as defined in section 2WA CRPC would be entitled to file an appeal before the court to which an appeal or I am reading, Your Lordship,
5.3,
page 14, 1-4, last fourth line in the bottom. It is quite clear.
Okay.
It is quite clear to us that a victim as defined in section 2WA CRPC would be entitled to file an appeal before the court to which an appeal ordinarily lies against the order of convictions. The language of proviso to section 372 CRPC is quite clear, particularly when it is contrasted with the language of section 378(4) of CRPC. The text of this provision is quite clear and it is confined to an order of acquittal passed in a case instituted upon a complaint. The word complaint has been defined in section 2D CRPC and refer to any allegation made orally or in writing to a magistrate. This has nothing to do with the lodging or registration of an FIR and therefore it is not at all necessary to consider the effect of a victim being the complainant as far as proviso to section 372 CRPC is concerned. So, Your Lordship, this paragraph explains that the term victim has got nothing to do with the complainant. Complainant may be XYZ and he may not be even victim. Now, the right which is provided to the victim under proviso to section 372 is not dependent upon the fact that whether the victim is a complainant or he is not a complainant. He has got the right to file an appeal. Then, Your Lordship, I am reading paragraph 5.4. In the said judgment, Deepak Gupta J was in complete agreement with Justice Lokul on the fact that victim must be permitted to access justice because it is sometimes found that the investigation, this is important, Your Lordship, because it is sometimes found that the investigating and prosecuting agency do not follow up the cases with zeal which is required and therefore proviso to section 372 of the CRPC must be given a meaning which is realistic, liberal, progressive and beneficial to the victim of the offences. However, Deepak Gupta Justice was of the opinion that one cannot ignore the rights of the accused and the procedure prescribed by law. Hence he disagreed with local justice view that a victim can file an appeal in the High Court without seeking leave to appeal in terms of section 378(3). Now, 5.5. The only difference of opinion was with regard to whether the victim is required to seek leave of the High Court even in an appeal filed in the High Court. While dealing with this issue, it was observed by Deepak Gupta Justice that prior to insertion of the proviso to section 372 of the CRPC, the victim had no right to file an appeal unless he was also a complainant. This was because the state would represent the victim of the crime. Why appeal was not filed to the district and session judge court? Because the state is prosecuting, state is representing. And when the state doesn't follow the right procedure, in this case, Your Lordship, what has happened? That the seizure list was made. In the seizure, so many documents were seized, and those documents were sent to the court Malkhana under MR number. When the witness came before the court, seizure witness, and they wanted to identify the material exhibits which were seized during the course of the investigation, were found to be missing from the court Malkhana. Neither the prosecutor who was prosecuting the accused person nor the learned trial court has taken any pain to make a small inquiry that how and in what manner those material exhibit got vanished from the court Malkhana. And they have though recorded the finding that ingredient of section 409 are satisfied, but the seized articles since were not produced, so benefit of doubt is given to the accused and they are acquitted. And that is why, Your Lordship, the right of appeal both against the original order as well as the appellate order is provided to the victim when he finds that the prosecuting agency or investigating agencies have not done their duties in the manner in which it ought to have been. They have a right to file the appeal. And it's not that they must first come before the district session judge. District session judge, because the state has already filed the appeal and they are the person who are representing me before the district and session judge in the appeal. But seized article, material exhibits were not produced. Whether it was there or not there, prosecutor comes and informs the court that material exhibits are not there, are missing from the court Malkhana. That cannot happen. And if it has happened, it must have been happened due to some understanding between the accused or against the officer of the court Malkhana, who is responsible for the seized articles. This was because the state would represent the victim of the crime. Therefore, the question whether the victim, while filing an appeal against the acquittal of an accused under proviso to section 372 of the CRPC in the High Court, is required to obtain leave under section 378(3) of the CRPC was answered in the affirmative. In this regard, reference was made to the subsection 4 of section 378, which deals with an appeal filed by the complainant. In case the order of acquittal is passed in a case instituted upon a complaint, in such a case an appeal has to be filed in the High Court. Such an appeal cannot be entertained unless the High Court grants special leave to appeal from the order of acquittal. Now, if this is an appeal filed on a complaint case, like CR case, then it will be, leave of the court will be needed. Subsection 5 provides the limitation period. I am not bothering this court. Subsection 6 lays down that in case the application for special leave to appeal filed by a complainant under subsection 4 is refused, then no appeal from that order of acquittal shall lie. Dealing with the concept of leave to appeal, especially when the appeals are filed in the High Court, it was observed by Deepak Gupta Justice that the presumption of innocence of every accused is fortified and strengthened when the said accused is acquitted by the trial court. Therefore, the High Court at the initial stage of deciding whether the leave is to be granted or not can go into the merits of the case. Your Lordship, then I take to Your Lordship paragraph 5.10, page 20. In light of the two opposite views, there were two views, Your Lord. One view says that leave is needed, Another view says the leave is not needed. In the light of two opposite views expressed in the above judgment of this court, it is necessary to discuss certain provisions of the CRPC and arrive at our own conclusion on the point for consideration. We observe that we are inclined to follow the view taken by local justice. Local justice view is this, that leave is not required insofar as the right of a victim of a crime to file an appeal is concerned. Victim and complainant both are different. Both are different. Victim may be complainant. Sometimes complainant may not be a victim. The victim, if he is only a complainant and not a victim, then leave of the court is required. Then, Your Lordship, I am a victim. Victim definition is provided in WA. Victim means a person who has suffered any loss or injury caused by reason of the act or omission by which the accused person has been charged, and the expression victim includes his or her guardian or legal heirs. Your Lordship, I'm a banking institutions. I have suffered a loss of lakhs of rupees, which is a public money, which was misappropriated by the accused persons. And bank is a victim in the instant case, and bank is before Your Lordship on a appeal, which has to be filed before the High Court. There is no other forum where I can file the appeal against the appellate order which has confirmed the trial court order. Your Lordship will just have a look on paragraph 6.6. Is internal page 31. Having regard to the insertion of proviso to section 372 of the CRPC, we find that in the case of a victim who seeks to file an appeal, he or she could proceed under the proviso to section 372 of the CRPC in the circumstances mentioned therein, and need not prefer an appeal by invoking section 378(4) of the CRPC, which is in respect of an appeal to be filed by the complainant. It may be that the complainant is a victim in certain cases, and therefore the victim has a right to file an appeal under the proviso to section 372 of the CRPC, and need not proceed under section 378(4) of the CRPC. 372 is corresponding to section 413 of the new law. Now, the word victim is derived from the word, I'm not so much pressing, then Your Lordship will come to paragraph 7.11, page 45. 7.11. A reading of section 378 would clearly indicate that in case the complainant intends to file an appeal against the order of acquittal, his right is circumscribed by certain conditions precedent. When an appeal is to be preferred by a complainant, the first question is whether the complainant is also the victim or only an informant. If the complainant is not a victim and the case is instituted upon a complaint, then subsection 4 requires that the complainant must seek special leave to appeal from an order of acquittal from the High Court. As noted under subsection 6, if the application under subsection 4 for grant of special leave to appeal from the order of acquittal is refused, no appeal from the under section 370. However, if the complainant is also a victim, he could proceed under proviso to section 378. Your Lordship, section 378, the section 372 is an independent court. It may be said that it's an independent court. It is not dependent or circumscribed by any other provision of the CRPC. I have a right to file the appeal both against the original order as well as against the appellate court order. Nothing prevents me. That is the law which has been settled now. Your Lordship will just have a look on paragraph 8, page 49. Page 49. The right to prefer an appeal is no doubt a statutory right, and the right to prefer an appeal by an accused against a conviction is not merely a statutory right, but can also be construed to be a fundamental right under Article 14 and 21 of the Constitution. If that is so, then the right of a victim of an offence to prefer an appeal cannot be equated with the right of the state or the complainant to prefer an appeal. Hence, the statutory rigors for filing of an appeal by the state or by a complainant against an order of acquittal cannot be read into the proviso of section 372 of the CRPC so as to restrict the right of a victim to file an appeal on the ground mentioned therein when none exists. Your Lordship, if the state wants to file the appeal, state also has got a right to file the appeal against the order of the session judge, confirming the judgment of the trial court.
Under what provision of law? State's right under what provision of law? Right to file appeal?
Right to file appeal is under section 378.
Where show us section 378 entails second appeal? Because state appeal will be second appeal.
State appeal will be second appeal. That is why leave of the court is needed.
Where it is provided the second appeal can be filed. You want to say that against the order of appellate authority, the further appeal will lie.
Yes.
What 372 specifically says?
372 specifically give a specific right to the victim.
Yes, and what it says, the appeal shall lie to the court, which an appeal ordinarily lies against the order of conviction of such court.
Yes.
Now, tell us against the order of conviction of the appellate court, where the appeal lies.
It will lie to the High Court with the leave of the court.
See, let us deal with the old CRPC.
Yes.
Or new one also, there is no problem. Now, it has to be provided under section 415 of the BNSS.
415
of BNSS.
Lordship.
Conviction.
Lordship.
It states where appeal will lie.
Yes.
Now, please point out where this state appeal will lie in such a case.
In such a case.
Yes.
It will definitely lie to the High Court.
374 doesn't say where appeal will lie.
Yes.
415 says. Now, please tell us where appeal will lie.
Your Lordship, by general analogy, I have to go through this BNS. And
because your entire argument bases on that.
Yes, Lordship.
Because you're right, you have a right, but then you can prefer an appeal only to the court where appeal lies.
Yes.
Against conviction.
Against
so
conviction.
You have to show us that you
not
right.
Against conviction, against acquittal.
That is no. That is what it says. See the proviso to 413 last line.
Yes. Shall be the court to which an appeal ordinarily lies against the order of conviction of such court.
You have to clarify on that, otherwise your entire argument will be of no consequence. It will have no bearing so far as this present maintainability is concerned.
Now 415, appeal from conviction. Appeal from conviction.
Yes, please.
Yes. Any person convicted on a trial held by the High Court in its extraordinarily original criminal jurisdiction may appeal to the Supreme Court. Supreme Court. Any person convicted on a trial held by a session judge or an additional session judge, or on a trial held by any other court in which a sentence of imprisonment for more than 7 years has been passed against him or against any other person convicted at a time trial, may appeal to the High Court. So here the right of filing appeal against the session judge order is in those cases where the imprisonment is for more than 7 years. 7 years. They are not convicted. They are not convicted. They are acquitted. (419) Your Lordship. Appeal in case of acquittal, save as otherwise. This is the state government.
It doesn't say where appeal will lie. We're talking about where the appeal will lie.
Yes, Lord.
415 specifically deals with that.
Your Lordship, 419 subsection 2.
Yes.
If such an order of acquittal is passed in a case in which the offence has been investigated by any agency empowered, this is for the CBI, yes, to the Court of Session from an order of acquittal passed by a magistrate in respect of a cognizable and non-bailable offence, to the High Court from an...
That is in a matter where investigation is conducted by CBI.
No, Your Lordship, that is only dealt with in subsection 2. This is again a independent. We cannot link it with the CBI.
No, we are just going, the last line of this provision to 413.
Yes.
So that is why you have to determine first where the appeal will lie.
To the High Court from an original or appellate order of acquittal passed by any court other than the High Court, not being an order under clause A or an order of acquittal passed by the Court of Session in revision. Your Lordship,
Are you reading that 419 subclause 2B?
Yes.
Which way it applies to you? Start reading subclause 2. It is only where an appeal is preferred by the central government. Investigation is a case where investigation is conducted by central agency. That means CBI.
Yes, Lordship.
So it is not.
No, if such an order of acquittal also direct the public prosecutor to present an appeal to the Court of Session.
Please read the whole paragraph, then that it will be clear.
Yes.
If such an order of acquittal is passed in a case in which the offence has been investigated by an agency empowered to make investigation into an offence under any central act.
Yes.
Other than this Sanhita. Other than this Sanhita means that not by the state police. The central government may subject to the provision of subclause 3. So this applies only in cases where investigation is done by central agencies.
Yes. Subsection 3, Your Lordship.
This is direction to PP.
That is what?
No appeal to the High Court under subsection 1 or subsection 2 shall be entertained except with the leave of the High Court.
Yes, Mr. General.
Verify on that point only, that where this appeal will lie.
Lordship, just give me some time to go through.
That is the crux of the issue.
Yes, give me some time.
Should have said so. 1 hour is wasted.
Not wasted, Your Lordship. We have come to certain things because this is a question, Your Lordship,
right from
which will have a bearing.
But
Which will have a bearing
right from
in
the inception, right from in the inception, we have made you this pointed query. Anyway, the respondent have also tried to make out a case of non-maintainability. In spite of that, we have allowed you to elaborate on it. But as my brother has,
No, Your Lordship, if I am unable to satisfy, then it goes. It goes. Your Lordship may say that it is, but give me a chance.
Our effort is to come to a correct conclusion.
Yes.
That is what.
And I'm to assist as far as I can.
That's what you should do.
And you have long-standing. Our expectation will be more.
No, Your Lordship, thing is this, very few.
When do you want it to?
Just after puja, we'll take
3 weeks.
Always.
Heard Mr. D.K. General, Learned Counsel, Learned Senior Counsel. For the appellant. Also heard Mr. S.D., Learned Counsel for the respondent number.
2, my lord, I am for respondent.
The matter was preliminary heard on the issue of admission of this appeal. In course of hearing, the Learned Senior Counsel has made a prayer that this matter may be adjourned for the day to allow him some time to prepare for the same. As prayed for, this is matter of 3 weeks.
If it can be made clear, my lord, if it can be also made clear that my learned senior is only on 413, so that I can also do research, my lord, because my learned senior is sitting on 419 and 419.
He is on admission, we'll take care.
Item number 2.
One thing is in there is succeeded.
Why not we inform the court?
I'll send the video.
Huh?
I'll send the video.
Huh?
I'll say.
Yeah.
Yes.
My lord, before my friend begins, my lord, this petition has been filed for clarification of the orders passed by the division bench, my lord. This is the order is at page 13, my lord. Order dated
8/5/2025.
No.
58, page 58.
Page 58, my lord. This order dated 28/8/25, my lord. Now, my lord, one of the parties have preferred an SLP against this order. While this application has been filed by one of the parties, my lord, one of the parties has gone and filed an SLP before the Supreme Court, my lord. Of course, they have not read that party as a party in the miscase, my lord. My lord, if I may take your lordship to page 58, my lord.
58.
Yes.
Serial number 6.
Lordship will kindly see.
Serial number
Several
6.
matters will disposed of by common order, my lord.
Yes, yes.
Now, on the page 58, my lord, respondent number 6, lordship will see Mariam Commerce Limited, Umbir.
Yes.
Then again, my lord. Now, this Mariam Commerce agreed by this order, for which they are seeking clarification, has filed an SLP, my lord. And the SLP number is also available. I can provide the SLP number. The SLP number 027471 of 25 and is likely to be listed on 26th of this Friday, my lord, before the Supreme Court. So, my lord, the same subject matter is before the Supreme Court also.
Then we'll put off this matter for
after vacation.
After vacation.
We'll not go into the issue of whether SLP was filed or not. That you can come later.
Just simply adjourn, your lordship. Simply adjourn.
On pre-made by the parties, let's this matter after 3 weeks.
2 weeks. Apply, your lordship.
Item number 3.
in this appeal, my lord, we have challenged the order passed by the learned single judge, my lord. Please, my lords. This appeal is directed against the judgment and order dated 9/9/2025. The limited issue here is, my lords, there was an order of transfer, my lords, which was given to the petitioner, the appellant before my lords. My lords would find the order of transfer at page 33 of the paper book.
Page 33.
My lords.
So this is the transfer order.
My lords, this is the transfer order dated 28/8/2025. My lords, I am at serial number 1.
Okay.
Lordships may kindly see, I am transferred from 67th Battalion to, my lords, RTC Jodhpur, and transfer type, it says administrative reasons. Now, this order came to be challenged by us before the learned single judge, my lords. Now, they did not file a counter affidavit, but they produced some instructions on behalf of the respondents, my lords, as to why I was transferred. And that becomes material for us, my lords, that those instructions, my lords, would find at page 94. These instructions were made part of the record, my lords, so we've brought it on record.
So they become pleadings.
Yes, my lords.
94.
My lords. If my lords have it.
Yes.
Well, it's para 1, your lordships will see WPC number 379 of 2025, FB Sri Sunil Kumar Savita, Commandant so-and-so versus Union of India, others before the Honorable High Court of Meghalaya, Shillong for quashing of transfer order dated 28/8/2025. Please refer to so-and-so signal dated so-and-so. Following instructions on the matter may please be provided to the learned adjudicator to place on record, please. Now, we are concerned with, I'll read 1 and 2 both, so that it is clear. Shri Sunil Kumar Savita, Commandant of so-and-so, enlisted in CRPF on 29/12/1998 as Assistant Commandant GD. He was earlier posted in 54th Battalion Srinagar, Jammu and Kashmir with effect from 28/8/2021 to 30th/1/2024. Consequent on his promotion to the rank of Commandant, he was posted in 67th Battalion Meghalaya, where he joined on 31st January 2024. He has completed 1 year and 7 months in the present place of posting. Normal tenure is, my lords, 3 years. Then para 2, my lords, is relevant for our purposes. The Inspector General Northeastern Sector CRPF Guwahati, via DO letter number so-and-so dated 6th of August 2025, had intimated that many instances of interpersonal conflict between Shri Sunil Kumar Savita, that's the appellant, commandant, petitioner, and Shri Sanjeev Kumar, second in command of 67th Battalion, have come to notice. My lords may kindly take note of this. Despite continuous counseling by DIG Ops and Intelligence so-and-so, NES, DIG Range Guwahati and IG NES, but there has been no improvement in the situation. Hence, IG NES recommended that due to the extremely strained relationship between the commandant and the second in command, leading to a lot of negativity in the battalion, both officers be transferred out of 67th Battalion as soon as possible. So, my lords, the reason for the transfer is, my lords, here. And if I can, my lords, make it concise, the two aspects. First, they say, my lords, that there was an instance of interpersonal conflict between myself and the second in command. And, my lords, there was some efforts at counseling which failed. As such, I've been transferred out. There's the purport of this. Now, your lordships would have seen that the transfer order, my lords, it simply says administrative reasons. Now, the main ground, my lords, on which we are before your lordships are that, my lords, it is settled law that transfer cannot be punitive. Transfer is not a punishment, my lords, that is envisaged under the CCS rules. This is the admit position. I'll take your lordships to that. The second aspect of the matter is, my lords, that if there is any interpersonal conflict as alleged as against me between myself and any person, my lords, in this case they're saying the second in command, then, my lords, there would have to be some record of it. It cannot be my lords, just a statement made by somebody saying that there has been some interpersonal conflict, because it is also followed up by a subsequent statement which says there was counseling. Since this was not working out, therefore a decision was taken to transfer both these officers out. Now, my lords, I will first take your lordships to the conduct rules, my lords. This is the CCS conduct rules. Copies for court, please. Extra copy. My lords, these are the CCS conduct rules of 1964.
See, Mr. Paul,
My lords.
the impugn order says, impugn order of transfer,
My lords.
it says for administrative
Reasons. My lords.
Now, it never said that because of the interpersonal conflict.
My lords, that's what I'm coming to. If the order was, my lords, an order simpliciter of administrative reasons transfer, my lords, there was nothing. Then my case could not have been what it is before my lords. But once my lords issued notice in the matter, these instructions were then placed before the court as to why the transfer was effectuated. What I'm humbly submitting before your lordships, my lords, is that the grounds mentioned in the transfer order were not specific. They were clarified by the subsequent instructions. So therefore, my lords, my transfer essentially has been on the ground of interpersonal conflict. Which is why I say, my lords, it is a punitive transfer. They don't say, like, my lords, if the case would have been, the instructions before my lords would have been that for administrative reasons, his presence is required at X battalion or Y battalion or Z battalion, my lords, I have no case. But there is specific mention, my lords, and brought on record, made part of the record before the learned single judge, saying that it is because of an interpersonal conflict that this person has been shifted out. Now, what I'm humbly submitting before your lordships is that under the conduct rules, my lords, of 1961.
See, Mr. Paul, if we go further,
My lords.
it could be a wrong interpretation, whatever the case may be. But if because of the interpersonal conflict that you have,
My lords.
the administration is put into disarray, put it that way,
My lords.
then naturally your transfer is justified.
No, my lords, it does not say so.
Not because it's not only you, it is also the
Other
other
person
side.
was already due for transfer, my lords. He had completed 3 years.
Para 3, I think at page 94.
My lords, I'll read, my lords. On receipt of the report against the petitioner, the matter was examined in this directorate. After considering all the aspects of the case and in order to maintain good discipline and morale of the Jawans of 67 Battalion CRPF as well as administrative and operational requirement of the force, accordingly he has been transferred to RTC Jodhpur and Sanjeev Kumar has been transferred to so-and-so on administrative grounds by reasons dated so-and-so. My lords, I cannot blow hot and cold at the same time. Either I have to say, my lords, it's administrative reasons. Then, my lords, my interpersonal conflict has no role to play. And here it is not transfer of one individual, my lords. They say there is a conflict between 2 individuals and both those 2 individuals are then sent off to 2 different directions. So it cannot be administrative reasons. Why I am taking your lordships repeatedly to my lords, the conduct regulations is, my lords, the conduct regulations, as your lordships are aware, is a specific set of rules providing for a certain behavioral mechanism to be maintained by every civil servant. I am required to do these things, my lords, in order to be within the parameters set by law to continue being a civil servant. If I am outside this, my lords, then it becomes a misconduct on my part. And if it is a misconduct, my lords, then under the rules, there can be a disciplinary proceeding against me and I can be removed also. The punishment is stipulated. There are 2 aspects, my lords. My first argument is that a transfer cannot be a punitive action. So if they say, my lords, at paragraph 2 that it is because of this interpersonal conflict, then, my lords, the transfer order becomes bad in law. my lords have rightly pointed out para 3. In addition to that, they say administrative reasons. If I read it again, my lords, after considering the aspects of the case, my lords, before that, on receipt of a report against the petitioner. So there is a foundation to that. So there is a report, my lords. On the basis of a report, there is some application of mind on the report. And, my lords, on the basis of that, some decision is taken. So the foundation is, my lords, an adverse report as against me. The admitted position is, my lords, I am not privy to this report. I do not know what report is there against me. If, my lords, there is an allegation against me that I have done X, Y, Z, the law requires that I be confronted with that.
But the law of transfer is a discretionary.
My lords, if it is a routine transfer, which is why I said, my lords, my foundation of my first submission is if it is a punitive transfer. And I'll place the authorities on this, my lords. So the law is settled. The lordships of the Honorable Supreme Court, my lords, have very categorically said that transfer cannot be by way of a punishment. And I'll place that decision first, my lords, before I take your lordships any further on this.
All known proposition, Mr.
My lords.
Transfer cannot be modified. It cannot be punitive.
My lords.
It cannot be against the statute.
My lords.
Statutory provision. So these are the.
My lords, so which is why, my lords, I come back to that original fact. If in para 2 and 3, my lords, and in para 3, I'm grateful to my lords get me to read it, because it says, my lords, it is on the foundation is a report. Now, if there is a report, I have to be confronted with that report, my lords. There has to be some reasoning that has to be asked from me, saying that, okay, there is a report as against you, there is a conflict as against you and Mr. X, which may be detrimental to the battalion, my lords. I am not disputing that. But in that event, my lords, they would have to then show before your lordships that I have been confronted with that report. And once I've been confronted with the report, my lords, somebody has reached a finding that no, A, this has indeed happened. B, it is leading to, my lords, misconduct on my part and lowering the morale of the battalion and the soldiers of the battalion. Hence, I am required to be transferred out, or any other action be taken against me. So, my submissions on two limbs, my lords. First is that there is no material. And if there is material, my lords, they would have to demonstrate before your lordships that there was material. The material was considered as per law. And, my lords, then they came to a reason saying that I have to be transferred out. That's one.
What you're basically saying is that if there's a proceeding as such, it has to be in accordance with law and due procedure, principle of natural justice to be followed.
Has to be, my lords. Has to be. I'll just place, my lords, one paragraph from one judgment. As your lordships have said, this is settled law. They've elaborated a little on it, my lords. This is 2009 2 SCC, page 592. If my lords kindly have internal page 597, paragraph 16.
16.
16.
Yes.
May I just read para 16, my lords? Indisputably, an order of transfer is an administrative order. There cannot be any doubt whatsoever that transfer which is ordinarily an incident of service should not be interfered with. Which is why I pointed out, my lords, by my normal routine transfers happen, my lords, after 3 years. Then, my lords, they say, should not be interfered with, save in cases where inter alia malafide on the part of the authority is proved. Malafide is of two kinds, one of malice in fact and the second is malice in law. The order in question would attract the principle of malice in law as it was not based on any factor germane for passing of an order of transfer and based on irrelevant ground, that is on allegations made against the appellant in an anonymous complaint. It is one thing to say that the employer is entitled to pass an order of transfer in administrative exigencies, but it is another thing to say that the order of transfer is passed by way of or in lieu of punishment. When an order of transfer is passed in lieu of punishment, the same is liable to be set aside, being wholly illegal. So, para 3, my lords, they say that there is a report against me. So, they would have to then demonstrate before my lords that there was this report. I have been confronted with that report. There has been a response to that report, my lords, and on the basis of the response, somebody has applied his mind and come to a finding that yes, the complaint is genuine, and B, my lords, that I have to be transferred out because of this. Now, in my humble submission, my lords, none of this is available in this instant case. Had the instructions that had been placed before my lords would have been simpliciter, my lords, saying that it is a routine exercise. This person was here in exigency of service, he is being transferred from A to B for administrative reasons or otherwise, my lords. I have no case. I cannot question it before my lords. But prima facie, my lords, here is a case where the order of transfer is punitive. And that is clarified by instructions placed before this honorable court. Not, my lords, in the transfer order itself, but they have gone ahead and said that it is because of this is the reasons we've transferred this gentleman out. In my humble submission, my lords, that is not permissible. Now, why I say that, my lords, is, my lords, under the conduct rules, now, it's rule 3, if my lords have a look, my lords, it's general. My lords have it.
Rule 3. Yes.
Rule 3, my lords. Every government servant shall at all times, and 3 is relevant, my lords, do nothing which is unbecoming of a government servant. That's 1. And, my lords, may kindly turn the page and come to Rule 3, 19. My lords. Maintain discipline in the discharge of his duties. So, if there is an interpersonal conflict between myself and a subordinate, my lords, which is affecting the morale of the battalion as such, that would tantamount to be an act of misconduct on my part. I am exposing myself to that. I am saying that it could be a case of misconduct. If it is a case of misconduct, my lords, then how it is to be dealt with is then placed, my lords, in the CCA Classification, Control and Appeal Rules of 1965. Now, under this, my lords, you've given copies? My lords, 11 is the penalties that are prescribed under this. I'd asked you for the entire thing, no? Procedure.
Yes.
My lords, the following penalties may for good and sufficient reason as hereinafter.
You are reading?
Yeah. Well, it's Rule 11, penalties. The 2 kinds of penalties, as your lordships would be aware, my lords, one is minor penalties, one is major penalties.
True.
So the minor penalties, my lords, would include censure, withholding of promotion, recovery from his pay, reduction to a lower stage, withholding of increments, my lords, and major penalties, my lords, would have been reduction to a lower stage at the time pay scale, reduction to a lower time scale or pay grade. Well, we can go to then at 7 there is compulsory retirement, 8 there is removal from service which shall not be a disqualification for further employment, and 9, my lords, dismissal of service which will ordinarily be a disqualification for future employment under the government. Now, the question here is, my lords, that there is a report. It is not said anywhere, my lords, that I have been confronted with that report or some explanation has been sought as against me. The second question, therefore, then naturally comes is, my lords, that if there was actually instances of interpersonal conflict which was detrimental to the service and, my lords, was lowering the morale, naturally, if the commandant and deputy commandant are fighting, my lords, there would be some kind of indiscipline in the force. So, if I am responsible for bringing in any indiscipline into the force, my lords, there would have to be some kind of communication to me. It just cannot be, my lords, somebody is wishful thinking somewhere saying that no, this has been done and therefore we're going to do this. The admitted case is, my lords, and I don't think my learned friend will disagree on that, that I have not been confronted with any kind of communication. There has not been any occasion, my lords, where either I have been asked to show cause or an explanation sought from me, or that I have been summoned insofar as this aspect is concerned, because they also say, my lords, there have been repeated sessions of counselling. The Lordships would have recollected page 94. They said repeated sessions of counselling. So if I am, my lords, asked to report somewhere for counselling with regard to a certain matter, there would have to be some documentary proof. Now the learned single judge, my lords, unfortunately, we pointed out before the learned single judge, my lords, that I am the commandant of a battalion. My lords, there was an act by this second in command of trying to commit suicide. As the commandant, my lords, under law, I am required to make a report of this incident and put it forward to the higher authorities. That I have done. I admit I have done that. That, my lords, in my humble submission, is not a case of interpersonal conflict. That is a case of conflict between the second in command and his wife. That is on record. Learned single judge, my lords, while passing the impugned order, simply says that even though, my lords, efforts have been made to show that he is no way responsible insofar as this conflict is concerned, the court will not get into that. What I am humbly submitting before my lords is that if at all, my lords, the transfer order is to be upheld, the first thing we'll have to see, my lords, that there is indeed some report against me. In the absence of any report, my lords will then take a prima facie view that none exists. Because if it existed, my lords, it would have been brought on record. Your lordships would have also noted at page 94, there is no date mentioned of the report. It simply says receipt of a report. So in the absence of any report as against me, no correspondence whatsoever against me, my lords, one fine day I am greeted with an order of transfer saying that no, you are transferred out. When I challenge it before this honorable court, my lords, of course at that point of time my challenge was very limited to, my lords, the rules, because the rules say that normal period of posting is 3 years. However, for administrative reasons, my lords, I can be transferred out at an earlier date. It's a settled law. For administrative, for exigencies of service, so at any given point of time I can be sent anywhere. I would not have any case.
Previous posting also, it did not remain. Your previous placement in 3 years, Srinagar also, was less than 3 years.
Well, that is a hard posting. Jammu and Kashmir, as your lordships are aware, that's a hard posting. So there the normal time may not. Because it says, I'll take your lordships to those rules.
No, you do not have.
Because it specifically says, it does not confer any right on me that for 3 years I have to be there. I'm not saying that. My limited case is, that if an order is, if I can use the expression, that there is some amount of stigma attached to this order of transfer. It is on the basis of something, which I have allegedly done. The least that is then required is that I have to be confronted with it. And when I'm confronted with it, there has to be an opportunity given for me to explain my position. Somebody, under the rules, there are the disciplinary authorities would then have to take a reasoned decision saying that no, for this reason, this report is correct. And there is nothing required further. And for whatever reasons, that as the Honorable Supreme Court uses the expression, an order of transfer in lieu of punishment. I think they've expounded it a little one step further, that sometimes maybe the authority, feels that will not inflict punishment.
That would be after, you see, the process is
over. There have to be something. It cannot be on thin air. My first submission is, the order was on thin air. B, if it is at all, for some reason, some act of mine that I have done that I have to be transferred out, then in that event, I would have to be given an opportunity of defending myself. And even after I defend myself, if the authority feels, that I am required to be transferred out, that itself is also bad in law, because an order of transfer is not contemplated under the law. Transfer is not an option. Had it been simpliciter an order of normal transfer, then of course these submissions would not have been there before, my lords. So I place reliance on para 94, where they say, that my transfer is effected because of the fact that there was an interpersonal conflict between myself and the second in command. On the basis of that, a report was drawn up, and somebody then took a decision, and they mention it at page 94. The matter was examined in this directorate. So they say that there has been some application of mind also. Somebody has examined it. And after considering all the aspects of the case and in order to maintain good discipline and morale of the Jawans of so-and-so, as well as the administrative and operational requirements of the force, he has been transferred to Jodhpur. So in my humble submission, my lords, then it was not open for the learned single judge to simpliciter say that I will not enter into that aspect of the matter. I'll take out to your lordships to the findings of the learned single judge. And that is a finding at, my lords may kindly have a look at page 102. And my lords, the learned single judge also records this finding at paragraph 6, 102. May I read, my lords? On the other aspect, that is the reason for the transfers observed here and above from the written instructions, the same was due to interpersonal conflicts between the petitioner and the second in command, which could not be resolved, and the said transfer was necessitated in the said circumstances in the interest of the force. Though efforts have been made by the petitioner to show that he is blameless in this episode, and the dispute or conflict was due to the mental condition of the second in command who has also been transferred, the court will not venture into further examine the matter on the contentions of the petitioner, but observes that no case of transfer being vitiated by malefides or that the same is punitive in nature or prejudicial to public interest has been made out. The matter regarding preliminary inquiry not being central to the issue also does not warrant any deliberation or legality or illegality. Once, my lords, I have challenged an order, the other side comes and says that it is because of this, and the law is, my lords, that it cannot be in this fashion. It was not open to the learned single judge to simply shut me out. This honorable court, my lords, would then have to examine what were the material that was available before the authorities to effectuate my transfer. Because it is admittedly, at para 6, your lordships have seen, the finding is recorded that my transfer is because of the interpersonal conflict. It's not because of any administrative reasons. Once this finding is reached by the learned single judge, my lords, the material on which the authority had relied for transferring me in lieu of punishment, I'll say, my lords, maybe in lieu of punishment, would have to be examined. And whether, my lords, the procedure as laid out under the CCA rules, insofar as examination of that report is concerned, that would also have to be examined. And then the learned single judge could have probably come to a finding that, yes, because of so-and-so reason, there is no illegality with the order. But that is not the case. The learned single judge simply stops short and says that we will not examine it any further. That, my lord, in my humble submission, may not be the proper course of action. And as such, the impugned order is to be interfered with. Yes, subject to what my learned friend says, my lords, I'll address your lordships.
Please, lords. Also, kindly turn to page 36. These are the rules, my lord. There is a standing order with regard to transfers. Clause 5, your lordship kindly says, my lord, tenure of posting. Page 36.
Yes.
May read clause A and B, my lord. A says, the normal tenure of all officers under the policy will be 3 years, subject to the provisions of para 5B of this SO. As CRPF is Central Armed Police Force of Government of India, it constituted under Special Act and is tasked with important operational duties regarding maintenance of security of the nation. Therefore, there are certain operational and administrative requirements of the force. In view of such requirements, any officer may be posted to any unit or office at any point of time. The above policy does not create any right for any officer for posting to a particular place or for a particular tenure as mentioned in para 5A. If during the posting of any officer it comes to the notice of the supervisory senior authority that officer needs to be transferred out at any time from present place due to administrative or operational reasons, then the concerned authority may transfer such officer at any time to a suitable place. Well, the rules though indicate 3 years tenure, my lord, but it then again the second breath says that there is no vested right. They can be transferred for administrative or operational reasons. Now, my lord, the instructions which I placed before the learned single judge, my lord, page 94. Lordship kindly turns to page 96, my lord. This has not been read out. The unit in such a situation, interference in the inquiry, putting pressure on witnesses and tamper with evidence by him cannot be ruled out. As such, is transferred from 67 Battalion and putting him under the command of senior officer was felt necessary and is also in consonance with the transfer policy. Besides, Sri so-and-so, second in command, has also been transferred out from 67 BN. So, my lord will see we have not impugned any blemish on blameworthiness either to the appellant before lordship or to the second in command, my lord. We are saying that we are conducting an inquiry, preliminary inquiry based on the outcome of that, but for the purpose of conducting a fair and preliminary inquiry, both of them need to be transferred because we'll need to examine the witnesses from same 67 Battalion and CRPF, my lord, in Shillong. Now, if the second in command remains, he'll influence the witnesses. If the appellant remains in the same post, my lord, he'll influence the witnesses. The department thought it fit to transfer both of them. Now, from this, my lord, in my humble submission, there is no blemishness or we have not impugned any kind of blame on him, my lord. So, we are only saying that we are conducting a preliminary inquiry and there are reports of interpersonal conflict between you and your deputy. So, in my humble submission, there is no allegation, there is no stigma in this order, my lord, and there is no reason for that because till now the preliminary inquiry is not been completed. We have not even come to a tentative view also whether the appellant is blameworthy, my lord, or his deputy. He is blameworthy. So the entire allegation that it is a punitive because there are some allegation against me, we are saying that there is an allegation of fighting between two persons. Now, who is guilty and who is not guilty, my lord, that is yet to be determined. But for the purpose of conducting an inquiry, number one, for maintaining the efficiency of the battalion, my lord, it is necessary so that both of them were transferred out for the time being. Now, the other person has not come before this honorable court. And my lord, for a transfer to be punitive, when a transfer can be called punitive, my lord? My lord, kindly refer to the judgment placed by my friend, my lord. Kindly see para 17 of the same judgment, my lord. Yes. Now, my lord, my friend is relying on this judgment is totally against him only. Well, kindly see para 17, it says, inquiry was initiated against the appellant in terms of allegations contained in anonymous letter. So, in this case, there was an anonymous complaint, my lord. Having regard to the directives of the Central Vigilance Commission, no inquiry could have been initiated against him, but it is beyond any doubt or dispute that in the said inquiry, the allegations were found to be untrue. That is not even the case in the right now, my lord. The inquiry has not been concluded. Despite the same, not only an order of transfer was passed out, but to a station which, according to the respondents themselves, was a harsh posting. So, my lord, and here is a case he's been transferred from Shillong to Jodhpur, my lord. Now, if they can establish that Jodhpur is a harsh posting as compared to Shillong, my lord, well, what I understand of the general notion is that Northeast is a harsh posting, my lord. Northeast, Ladakh and Jammu and Kashmir. He has been posted to Jodhpur, my lord, and to say that he has been punitively transferred with a malafide intention. In my ombudsman, there is no merit in this. There is no material to substantiate that it is a penal transfer in any manner, my lord. Kindly see, he has been transferred from Shillong to Jodhpur, my lord.
No, but the issue of harsh posting has not been raised by the.
No, my lord, he is raising the issue that he has been transferred as a penalty. Because now, what is penalty, my lord?
Yes, the aspect of harsh posting or otherwise has not been.
My lord, what I am trying to submit, my lord, a penal transfer is when somebody is sent, okay, I am sending you to some place, okay. But I am sending to you a better place than Shillong. Can some malice in fact or malice in law be attributed to that, my lord? Had he been transferred from here to maybe, for example, my lord, Manipur or something, he has been transferred to Jodhpur, my lord, in Rajasthan. So, the transfer order to be penal, my lord, there has to be some penalty in that. Where is the penalty in this case, my lord? Third aspect, my lord. He is a commandant, he has been transferred as a commandant, and I'll submit him to transfer to a better place, my lord. It's transferred to Jodhpur, and the order that has been issued to him simply says, my lord, for administrative reasons. There is no stigma attached. My friend's submission was that it is a stigmatic transfer. By lordship has seen the transfer order, it simply says transfer to Jodhpur for administrative reasons. Now, what can be the administrative reasons, my lord? If two officers in my battalion are fighting, my lord, for a department, is that not an administrative reason to take some remedial measure, my lord? In my humble submission, that is a sufficient administrative reason to transfer both of them, to hold a proper and fair inquiry into the matter, my lord, and then ascertain who is blameworthy, and maybe disciplinary actions will follow, my lord, against the person, maybe the appellant or maybe the other person, we don't know, my lord. So that will be subject to the outcome of the preliminary inquiry, my lord. So in my humble submission, my lord, transfer is an incidence of service. This has been done purely for administrative reasons, because two of our officers are fighting among themselves in office, my lord. How the battalion will function, my lord, and they have to take care of the law and order duty in Shillong, my lord. So in my humble submission, my lord, there is no stigma, and the question of CCS rules will not even come into picture, my lord. CCS will come if we find him guilty in the preliminary inquiry. Then proceedings will be initiated against relevant clauses of CCS rules that you are found or you are charged with. These are your misconducts you committed. That question will come later, my lord. But as of now, even that stage is not come, my lord. So, my lord, in my humble submission, to sum up, my lord, this judge, number one, it is not a punitive or penal transfer, because to be punitive or penal transfer, there has to be some penalty attached to that, my lord. He has been sent to some harsh place, some bad place, my lord. In fact, he's been transferred to, if not better, is equivalent place, my lord, in the same post. There is no diminution in post or any kind of penalty, my lord. So, in my humble submission, my lord, the finding of the learned single judge that there is administrative reason for his transferring, and the second person who has been transferred, he has taken his charge, my lord. He has already been relieved from his post. That they have brought on record by way of additional affidavit on 10th of September. He has been relieved from his post, my lord. So most probably he is on leave to pursue this case, my lord. He has not gone joint till now. So, my lord, in my humble submission, there is no reason for interference with the finding of the learned single judge, my lord, because bringing him back, my lord, because we are concerned with that the preliminary inquiry should be fair. If he is commandant, he comes back, my lord, as a commandant, and he is the top officer, the head of the battalion, my lord. So there cannot be a fair inquiry into circumstances. That's my case.
Just to quickly respond to what my learned friend has argued, the first thing I'd humbly submit before my lords is, any authority cannot be permitted to blow hot and cold at the same time, else doctrine of approbate and reprobate will come into play. Merely because by way of clever drafting, we cannot really get away with something. Because I'll say, my lords, again in paragraph 3, they say there is a report. In paragraph 3, they say there's a report. In para 2, they say there's an allegation, there was counselling. Para 3, they say there's a report. Now, what my learned friend now placed before my lords at page 96, they say that on the basis of the report, there has been a P. And, my lords, pending P, there has been a transfer. Now, the question, therefore, I ask myself is, my lords, and which my learned friend also asked this question, is if two people are fighting in a battalion, my lords, would it not be administrative reasons to transfer them out? My humble submission is no. And an emphatic no at that, because an administrative reason is, my lords, for the better working of the force in general. It is not to plug a hole at a certain place. Somebody, my lords, is working in place A. It is understood, my lords, that he would function better in place B for whatever reasons. The authorities take a decision, my lords, that he will be better placed at place B. Transfer is permitted. So that would again defeat the argument that's been made by my learned friend that for the PE, for the purposes of the PE, these people have been sent out. There is no formal inquiry. If there is no inquiry, my lords, my friend said that it has not reached a stage where, my lords, there is a inquiry as envisaged under the rules that has been drawn up as against me. In other words, a disciplinary proceeding. If there is no DP, my lords, where is the question of pressurizing witnesses? If I have to exert my wrongful authority on pressurizing some witness or otherwise, my lords, there would have to be a proceeding. What I'm first submitting before your lordships is there is no proceeding. If there was a proceeding, my lords, it would have been brought to your lordships' kind notice that this is a report, this is what has been done, this is still where the stage at which we have reached, and therefore we thought that a P should be drawn up. And P, my lords, P is an internal inquiry. If it is an internal inquiry, my lords, there's no question of pressurizing any witness. Usually, my lords, in these kind of matters, your lordships, there can be instances where suspension, that is, my lords, what my learned friend is probably referring to is suspension in anticipation of a DP, which is usually done, that the person is suspended in anticipation of a DP which is drawn up, so that he may not interfere with the inquiry. It is not transfer. And suspension is very much one of the, my lords, interim measures which are available under the CCS rules as well. So if they, after the internal inquiry, my lords, they come to a finding, no, there has to be a case of a DP, which would, as my friend said, my lords, would be established only under the, my lords, the CCA rules, after holding a proper inquiry. In anticipation of that inquiry, my lords, I can be placed under suspension. Where is the question of transfer coming in? Transfer is not something, my lords, that it's not like a trump card that, if I may use the expression, it's not a trump card that I can pull out of my pocket and throw it at anybody at any given point of time and then come up with 3 different explanations in the same instructions placed before this court. First instance, my lords, I say that there is interpersonal conflict. Second instance, I say there's a report. Third instance, I say there's a PE. And fourth, I submit before your lordships, my lords, that as on today, the matter has not reached a stage of inquiry. If it has not reached a stage of inquiry, where is the question of, my lords, interfering with the witnesses? There has to be some rationale behind in whatever action has been taken. And those records had to be placed before my lords. So, my lords, the finding of the learned single judge at para 6, that it is because of interpersonal conflict, but I am not going to enter into that realm, my lords, in my humble submission, is not correct. And an administrative order, my lords, for administrative exigency, your lordships have, well, there are numerous judgments on it, what constitutes an administrative exigency. What my learned friend is saying, that 2 people fighting would also constitute an administrative exigency, my lords, I will most humbly beg to disagree with my learned friend. That would be an act of misconduct by me, because otherwise also ostensibly, my lords, I will be held liable because I am the commandant of this battalion. The other liberal, the submission that my learned friend has made, my lords, that he has been transferred to a better place, my lords, it is not the case. And that is apparent from the transfer order itself. Because here, my lords, I was the commandant. I am in charge of a battalion. Now, your lordships will kindly see at page 33 where I have been posted. I have been posted at RTC. RTC, my lords, is a regional recruitment training center. Recruitment and training center. So basically, my lords, from a command of a certain battalion, I am taken away and I am put in charge of, my lords, I am put as second in charge of a training center, which is headed by a DIG. My service conditions are changed. So what is being sought to be argued by my learned friend, my lords, that it is not a harsh transfer or that it is not punitive because he's a commandant here, he'll be a commandant there. It is not the case. Had I been transferred to a battalion, yes, probably this could have been an argument. That you are the charge of a battalion A in Shillong, you are now in charge of a battalion in Rajasthan. I am put in charge of a training center, and your lordships are aware when people are put in charge of training centers. So, in my humble submission, my lords,
I don't think lordships are aware about that, my lord. The SPs are very frequently transferred to police command. This thing, my lord.
Under what circumstances, my lords, we all know. Sometimes a lot of things is not said, doesn't mean that we don't know about it. And I'm sure your lordships will be echoing the same.
We're just given a vague idea of somebody being sent out to an unwanted place.
But Jodhpur,
my lords, usually when there is a transfer of regime, and this is, my lords, of course, off the record. Usually when there is a change of regime, my lords, and certain blue-eyed persons have to come in.
There's no change in regime in this case.
No, I'm just giving a normal. I am not. I'm not talking about a change in regime here. That's why I said it's off the record. well, when there is this, then certain people have to be shunted out. And so the best place for shunting out people, Melons, who are not so favorable are usually training centers or schools. And that's the blunt reality of today. And I am not in command of a battalion, Melons, so definitely it is not an equivalent transfer. Otherwise also, Melons, I would humbly submit, for any of this to be sustained, they would have to have brought it on record. It cannot be on thin air. Some gentlemen, Melons, cannot be sitting somewhere and writing instructions simply saying that, Melons, it is because of a reason A, B, C. And in contemplation of, Melons, if I am well versed with the law, I know that I will call it a P, and in lieu of suspension, Melons, I simply use the word transfer. Suspension in lieu of suspension pending inquiry, Melons, is heard of. Transfer pending inquiry, Melons, I have not heard of it.
Yes, of course.
Highly obliged.
Well, one aspect I missed out. If he is alleging malafide against somebody, because his pure case is that it is a victimization, malafide, punitive action taken. He has not pleaded, not arrayed anybody as a respondent in his personal capacity if he is alleging malafide against anyone. What my friend said, that someone sitting somewhere has taken some action against him to penalize him, a change in regime. I don't think these are even the pleaded case we were learned single judge.
Change in regime was on a different context altogether. Change in regime was in a different context. Otherwise, also the law is that I don't require to make any personal allegations against anybody. I am saying it is a punitive transfer.
We've heard the parties.
Right.
Judgment is reserved. But can you just give a short note
By tomorrow.
By tomorrow, yes.
By tomorrow. There's some urgency in the matter, as my friend pointed out. By tomorrow. Obliged.
Heard Mr. Kipol and the Senior Counsel, along with the appellant. Also heard Dr. N. Musika, DSGI.
Yes.
DSGI, along with. Hearings concluded. Parties, judgment reserved. Parties are to, as per for, parties are to file their brief written synopsis by tomorrow.
Tomorrow is Thursday. I'll give one extra day until Friday.
I have no difficulty, Malaj. My difficulty is what my learned friend pointed out. That they've relieved me. If they say you can stay here, Malaj, I have no difficulty.
Well, I'll try.
Whatever has been submitted was not so complicated. We can understand
I'll do that.
It is just for our convenience.
Yes.
This is.
I'll do that.
One page note, Malaj. Give a one page note. Highly obliged.
Item number 4.
My lord, we'll have it after vacation.
My lord, I would only submit, my lord, your lordships have heard on the merits, my lord.
No. I have not completed.
No, he has not made submission. I have made, my lord. My lord, there is a petition pending for suspension of the sentence and grant of bail, my lord. That may be taken up for consideration, my lord. And on merits, of course, the arguments.
But Mr. Chakravarti, like you said, your argument is already completed.
My lord.
He is just to advance his argument. That will just be a matter of time.
At the most one date, my lord.
At the most one day. So we might as well hear the whole matter and then dispose of it.
My only request would be, if the matter is shown to be part-heard, my lord, it will come up on the top of this.
We can.
It is better for both of us.
Yes.
It may come up as part-heard.
Heard Mr. S. Chakravarti, Senior Counsel for the appellant. Mr. R. Gurung, Leonard GA, has submitted that he may be allowed to respond on the next date. This matter is accordingly kept as part-heard. List the same after 2 weeks.
Okay. All right.
Item number 7.
Lordship, arguments have concluded in this matter, Lordship.
We filed our written arguments also. And written
So I saw that junior Sharma, she was here. Got it fed up. On pre-made by the parties, let's this matter after 3 weeks.